lease value. I'll take up India in the next week.
Please give us.
Mining matter मतलब for execution of the lease agreement में kindly be listed or else the matter would become infructuous.
Extradition matter मतलब
Yes, admission. Appeal material.
Pardon to make a mention, my lords. My lords, herein the petitioner has challenged the illegal cancellation of his lease deed, as well as he has been blacklisted indefinitely. My lords, I pray for tomorrow. I pray for tomorrow, my lords.
We'll see it then. You have mentioned everything in your. Sometimes slips are rejected also because I am not in a position to decipher what has been mentioned.
My lords,
So,
it's been clearly stated.
because of handwriting, whatever. If everything is mentioned clear, then I will.
Pleasure.
माय लॉर्ड इन पर्सन मैं करता हूँ बैंक ऑफ बड़ौदा केस का। माय लॉर्ड 2022 से मेरा कंटेम्प्ट चल रहा है। मैं बहुत बार ट्राई कर रहा हूँ लिस्टिंग करने के लिए माय लॉर्ड। अभी तक मेरा मैं लिस्टिंग दे रहा हूँ, नहीं हो रहा है माय लॉर्ड। थैंक यू माय लॉर्ड।
Matters under the heading orders. Item number 20.
My lord, I filed this case to recall the order dated 16/3/2022 as because the matter was dismissed of I could not able to connect due to the poor internet. The matter was I could not unable to place the matter. The matter was disposed of.
How can you file IA? You could have filed a review application. But how can we dispose of matter? We can entertain interlocutory application.
More problem with that the honorable division bench disposed of on merits, lords. If a lordship look at the order, said that
He was not there.
so he could have filed a review so that but
So you file a review.
Lordship may give a leave.
Which is the impugned order?
Impugned order is the annex of 12, my lord.
Dated?
Dated page 41, my lord.
Dated.
Dated 22/8/2013.
22/8/2013.
no, impugned order means a rejection order.
Rejection order was disposal by this honorable court, that is 16/3/22.
16/3/2022.
My lord. The honorable court held that there is no illegality committed by the tribunal.
You file a review.
My lord.
Explain the circumstance in which you were absent. And you can make a mention. You will take up your matter on priority basis. Because you were not heard when the order was pronounced. File a review. The number conflict of the commissioner does not press this application, but seeks a liberty to file a review application, a review/recall application for recall of the order dated 16/3/2022, which was passed in the absence of learned counsel for the petitioner. Yes. Just comma minutes. Review or recall on the order. Slash recall. All right, and then we make a mention.
Item 21.
That's a delay of 184 days. The impugned order is at page 16. Disposed of at the stage of admission with a direction to regular use. That is your lordship. Keeping in view the judgment passed in case of Patita Pavan Dattadas. That is notice.
Main matter bound.
What is the defect? So please have not stand. You have to file an application for dispensing. You are not given the copy of the.
Or you file.
Either way.
You file.
The respondent by Richard Post, like, after filed by 28 10 2024. This is not a subject to removal of defects. Notice the question of condemnation is a subject to removal of defects. Yes. Third.
Item 22.
There is a delay of 204 days. The issue, my lord, case of the petitioner disposed of in terms of the judgment in case of another order passed by the Honorable Single Judge in case of Devendra Kumar Naik, where there is a direction for absorption. In fact, those petitioners were retrenched in 2002. Writ petitions were filed in 2013 and directions were passed for their absorption, keeping in view an order of the tribunal. Now, referring to that, this case has been disposed of by page 19.
That order
On-
of the tribunal, which it was based.
That exactly, I don't have that instruction.
Well, had you filed counter affidavit in that case?
In this particular case, no counter has been filed. It has been disposed of at the stage of admission.
Admission first date.
First date, it has been disposed of.
IA 2826 2023. Filing of certificate copy that is allowed. 2828 of 2023. Procedural response checking, question of condemnation of delay. Returnable within 4 weeks, 6 weeks.
6 weeks.
Returnable within 6 weeks. And within 6 weeks. If this shall be filed by 27, 2000. If this is issue of notice shall be filed by 27, 2024. This is the case on
3rd December.
3rd December.
Item 23.
Item 23, there is a delay of 919 days.
Must be, have you filed or? Must be 85 days. But Sarachandra Padida.
But I get that your lordship has fixed all the matters to 11th November. The pension of block grant employees.
Stated that similar matters, Mr. similar matters are posted to 11/11/2024. This case on, this case with those cases, what do you now, please give a number.
Yes, ma'am, the batch case.
2949 of 2023. 2023.
Here, the traditional government advocate that similar matters, bracket the WA 2949 of 2023 and bad are posted to 11/11/2024. This case along with the, along with those cases on 11/11/2024.
Item 24.
24, my lord, is a delay of 730 days. The read petition was disposed of at the stage of admission with a direction to regularize the service of the petitioner. The specific direction that is at page 19, the operative portion, my lordship.
But what about the NSC? I think there are tax collectors in the NSC.
Yes.
Mister, have you please examine the High Court rules. How a writ petition is required to be resolved. So everyone will have to, and we will have to, it seems, we may have to lay down this thing, law dealing with the procedure under the High Court rules. After filing of a writ petition, whether notices are required to be issued, whether you have to wait for the High Court rules. See, it is clear. Rule 9, unless the court sees, please see. After removal of defects, the matters are to be placed. See there. This is at page 49.
Okay.
At page 49.
Yes.
addressed in one of the cases. And please examine whether there is any, this aspect has been dealt with or not ever. So this is a procedure which all of us are required to follow. See, an application can be disposed of on the first day if there is no merit.
Yes, as per rule.
This is what the rule says.
Yes.
And if it is not rejected at the stage of admission, then a date has to be fixed.
First fixing the show cause. File the
File the
reply.
counter-affidavit.
That is the requirement. Yes. Where were you?
Item 24 to be called out. 24.
7:33. IS 4367 of 2023. So here are you going to file the certified copy or?
File the, Lordship, we have filed an application to dispense. File this.
No, certified copy, what problem do you have? Subject to problem? File certified copy, what problem do you have now?
No, in the dispense petition, we have taken a stand that we have applied but not received. That is why they have, that is why the plea being taken. But we'll file the certified copy.
File it. Certified copy.
Receive. I'll
No,
verify.
not that. Now they can get certified copy within a day. Within a day.
4367 of 2023. This I have been filed for dispensing and filing of certified copy of the impugned order dated
Impugned order dated 11/6/2021.
11/6/2021, passed in WPC number 17451 of 2021. 4 weeks time granted to the petition to the appellant for filing the certified copy. The IA is accordingly disposed of. IA 4365 of 2023 condemnation of delay. Issue notice on the question of condemnation of delay to the sole respondent by registered post or speed post with AD returnable within 6 weeks. Full stop. Vigilance shall be filed by 20/10/2024. List on
30 December.
3/12/2024.
Item 25.
Item 25 will 180 days delay. This is regarding that pension of the employee. My lord, Lordship can fix it to 11th November.
Same order as in item 23. All right.
Yes, my lord. And sir, 26, 26, 27, 28. All these matters are
26.
27 and 28.
23, 25, 26, 27, 28.
My lord.
Is anybody appearing from the respondent in these cases?
No, my lord, no.
Who's asking, sometimes they appear,
Yes, ma'am.
I think 30 also.
30, 30.
30 also.
Yes, ma'am.
Item 29.
In 29, there is a delay. 279 days.
What is this about?
There is the regarding the regulation of a retained employee that relying on this honorable court that Saroj Kumar Das, that judgment in the meantime has been set aside by my lords. Lords may issue notice on the question of limitation. That I have forgotten that number.
If you notice to the sole respondent on the question of condemnation of delay by registered post, public speed post with AD returnable within 6 weeks. This is the case.
And
No,
this-
no, returnable 4 weeks.
Right.
Returnable within 4 weeks. List on 3/12 or 3/12/2024. Yeah, refusal shall be filed by 28/10. The miss करेगा मुझे write the same thing. 28/10.
Item 31.
I think, yes, Mr. Mishra is there. When did we keep those matters? Yesterday's matters, he was appearing, I think similar matters.
Similar same matter. Yesterday's
It has already been disposed of.
Yes.
My lord. This is covered by my lordships have already disposed of many writ appeals, my lord. Because it has been set at rest because after the confirmation with the Honorable Apex Court, my lord. I have given that order.
I wanted to check the same. That's your lordship.
It has already been implemented in some
Demonstrators claiming UGC scale.
So one college it had been decided, so the.
Yes, in respect of university employees.
Rajdhani college.
Such order passed by this honorable bench in WA number 1192 of 2024.
That copy I have given.
Yes, yes.
Yesterday.
37. Yes.
Stand there on record. In terms of this, it's not a little bit, Mr. You said you have appeared yesterday.
My lord, already happened.
The DN Mishra. Yesterday we recorded your name.
My lord, already been passed.
Order is there.
DN Mishra, this order. Cases. You appeared, but you appeared in one, I think.
One only, a second one.
Second one, you should notice that. Yeah.
You have appeared in,
He's appeared in
I think one way.
you can dismiss it.
953, yes.
You can dismiss no.
The exact order, secondary need not write that third, the responding to notice that. All right, same order.
Item 32.
Yes.
32, there is, your lordship has issued notice on the question of limitation.
Both the cases, Contempt appeared.
In the second matter, the lordship, by the common judgment, two writ application we disposed of. One has already been upheld by the Honorable Division Bench and the Honorable Supreme Court.
Validity of method of
Very on the ground of delay.
A delay in the Division Bench and in the Honorable Supreme Court, the lordship may kindly see page 21, page number I have done.
not a copy.
Want to check?
Yes, madam.
First one election to.
The first one.
Not connected.
First one I connected now. Because only two writ applications were disposed of by the common order. So for this.
Granted aid and area claim, it's not that.
I
Same,
don't know about the first.
same.
Same.
First election to your WA 468 of 2024. List tomorrow along with WA number 465 of 2024.
No, we will not do that. In fact, Supreme Court says, yes, question of law is left open. So, the ground of limitation that was, we will decide the question of law. Just come tomorrow.
Is WA 465 of 2024 also list tomorrow? List tomorrow.
It is already listed
Sorry?
on the list. 465 also on the list.
Both we are adjourning to tomorrow. But you write down the name of the counsel in this case, other case for responding right now.
Item 33. 33.
There is a delay of 45 days.
But 45 days delay, but the unmarried daughter has got directed to receive family pension.
Yes.
What ground are you challenging?
No, my lord, here the pensioner, the father of the petitioner, he was entitled for the pensionary benefit in terms of a triple benefit scheme. Because they were appointed in ex-state schools. So subsequently, after
Then we can decide.
Yes.
Alright.
But the entire each person they have admitted before the only single judge. This is covered matter. According to only single judge passed the order. Can the consumption kindly see the order matter? The order they have fairly considered.
It's a covered matter and it is not a covered matter. So do we have to accept that?
Accepting
We
they
take
have
acceptance of the state council, but his word is not final. Because who appeared on that day, we cannot say.
but after filing counter they have matter heard and they have considered that
That is concession.
See, Mr. Counsel, there can be concession or admission on facts, not the point of law.
law they have decided this case is covered by and because of question they are covered.
Therefore, we shall follow their submission.
No, that my submission is
Are we bound to follow their submission? If they make a wrong submission, or if you make a wrong submission, or if you make a wrong concession on the question of law, are we bound to accept that?
no, that is not the no, that I'm not just I am
All right, we will consider that.
my lord. The pension also fixed is contempt to 1811. I pray any date before that date. 1811 also fixed the contempt. Because in conduct proceeding,
Don't press that.
No, I have not proceed. Before the date, any short date my play only.
Okay. 04 of 2024 dispensary. IA 3203 of 2024, there is a delay of 47 days in filing of this writ appeal. Heard Mr. Sasadas, learned additional government advocate, and Mr. L. Mahanti, learned counsel appearing for the sole respondent. Considering the period of delay and the reasons stated in the application for condoning the delay, we are satisfied that it is a fit case where the delay should be condoned, full stop. Prayer for condemnation of delay is allowed, the application is accordingly disposed of. Have you received a copy of the appeal memo?
I'll serve
The day or later?
by tomorrow.
Sir, then in the writ appeal you write. Mr. Das, learned additional government advocate, undertakes to serve a copy of the appeal memo on Mr. Mahanti, learned counsel for the appellant by tomorrow. List the case on 5/11/2024. For fresh admission.
Item 34.
34 on behalf of Mr. Mishra. Well, in the meantime, I will file objection to the limitation.
Which Mishra?
Sir, ready, madam.
100.
54 days.
54
days.
54.
54 days, for 54 days, really we will
In the
wait for
meantime,
Mr. Mishra.
well, in the meantime, what happened? The order of the honorable single judge has already been implemented and certificate has already been issued, madam.
All right.
Fine.
Should be happy.
So given this cause of action,
We are condoning it.
I may apply next week on behalf of Mr.
We
Mishra.
keep it for fresh admission next week. IA number 4775 of 2024. There's a delay of 54 days in filing the writ appeal. Consider period of delay and the application. For explaining the delay, we are satisfied that this is a fit case for that the delay should be condoned in the interest of justice. Full stop. The prayer for condemnation of delay is allowed and the IA is disposed of. List for fresh admission on 5/11/2024.
Okay.
Item 35.
I am for the respondent, my lord. Number
Item
1.
35, Your Lordship, may kindly permit me. If Mr. D.R. Bhokta is appearing in this case, Your Lordship, may kindly call this matter next week.
You are for whom?
I'm for the writ appellant, but Mr. D.R. Bhokta is appearing in this case. He's filed this case. Your Lordship, may kindly call this matter next week. Is a little indisposition.
No, condemnation.
Next week, any day, Your Lordship.
No, 588.
Or
And please ask Mr. Bhokta to file a proper date chart and a synopsis.
My lord.
File 3 line synopsis.
Yes, lords.
Yes, sir.
either he might have understood the merits of the case also. Therefore,
Lords.
all right.
Mr. S.S. Kashyap, Planet CGC, prays for an adjournment on behalf of Mr. Dipyaranjan Bhokta, Planet CGC, list the case on 5/11/2024. Mr. Sapan Kumar Pal and the council appears on behalf of the respondent.
Yes, ma'am.
Panjega.
In the meantime, I have filed an objection regarding limitation petition, my lord.
Before that, one line, Mr. Sapan Kumar Pal has appeared for the sole respondents, submit that he has filed the objection when?
Today I have filed an objection.
That he shall file the objection to the application for condemnation from delay in course of the day, list on 5/11/2024 along with the objection.
Obliged.
Item 36.
In this case, my lord, there is a delay of 1717 days to file the CMAPL restoration file, my lord. Is appearing in for the opposite party. It is a matrimonial appeal, my lord.
Nobody is appearing for the office, not that. Notice was issued in this matter after 4 years of filing of the matrimonial appeal. Notice went and it returned unserved. So how can you say nobody is appearing when there is no valid notice?
My lord, no, my lord. That is that in that address he is taking money
How
in
can
that.
you say that nobody is appearing when notice has not been served? It has returned unserved.
Earlier once served, my lord, tar jo owner ko, my lord.
What I found from the order.
Justice B.K. Naik when sitting in that.
Please don't mention name. You mention the date.
My lord, पकड़ से date टा नहीं.
This appellant doesn't seem to be interested in.
My lord, is he taking money in the lower court in the criminal proceeding 125 proceeding, my lord, same address. Also, warrant was issued to the petitioner in the same address, my lord. But she is not receiving. I'll undertake to petitioner, my lord. 125 proceeding is delay ହେଇଯାଇଥିଲା ତାକୁ payment କରିବା ପାଇଁ.
So warrant will be issued to the appellant, not the respondent.
No, my lord, in the same address. It is the address. She is not receiving. I'll to undertake, my lord.
Who is the maintenance? The husband or the wife?
Husband, my lord.
So issued to whom?
Husband is also filed this case, my lord. Wife address was same, my lord, in that warrant case, my lord. In 125 petition, my lord.
You're a Hindu manager. We are adjourning the matter for a week.
My lord.
We are adjourning we may adjourn the matter for a week. Seek instructions from your client. We may impose exemplary cost.
My lord.
In this case. You can just tell him. This is not the way the husbands should behave.
Because of my mistake, my lord, that was
Because of your mistake, 1 day, 2 day, 3 day, 1 month, 2 months, after so many years.
My lord, COVID period. My lord,
COVID period.
Because
when
of
was
that,
the order?
we unable to contact the
when
client.
was the order passed? When was the decree issued?
2014, my lord.
2014.
Immediately I have filed, my lord. After the decree, we have filed only 3 days delay in that petition, my lord. That notice was issued, but see.
Notice issued 2019.
No, my lord. Earlier also notice was issued several times. On that date, court has directed me to take instruction for paper publication. But because of my mistake, my lord, it was dismissed for default, my lord.
Oh, madam.
All right. one day it could be because some mistake he could not appear.
And you can file fresh application. Who brought-
Immediately, when he contacted me, I am immediately filed, my lord, this.
That means after 10 years he contacted you.
After 4 years, after the corona, he is a
See your petition.
my lord. He,
Condemnation of delay petition, CVD.
my lord. I have filed the case, my lord, on 14/5/2024, my lord. He contacted me 13 tarikh, 13/4 re. Immediately I have filed, my lord.
He has filed since 2014, he contacted you in 2024.
In that period, he has some problem. I unable to contact him because of his addresses are not properly. Also, his advocate was also.
Madam, you can tell him. We have understood matter about. You can tell him that we are inclined to dismiss this application prima facie. You may convince us on the next date. Otherwise, we may take up also, but we may impose exemplary cost if we are not satisfied. And convey 1 week, 10 weeks.
1 week, 1 week.
1 week further.
Exemplary cost means how much he will take.
Huh?
We are saying the nature of the litigation. In your case, divorce
He is a
not
poor
granted.
beetle shopkeeper, my lord.
On of his conduct, his application for divorce has been dismissed.
Yes.
Filed in 2014. Matter is pending since 24. Since 10
His
years.
advocate.
Why should the wife be dragged to the court after 10 years? That is
Earlier also, she is.
not a normal writ petition which has been dismissed. That
Beg your pardon, my lord. In this, the earlier matrimonial case also, she is not appearing. Ex parte order has been passed. She is only contesting the 125 proceeding, my lord.
we are talking about he, not she.
That lady, my lord, not appearing in that case earlier. In the court below. In the High Court also, she is not till date appearing.
Alright, you
Several
can make
times
an
notice
application.
was issued, my lord.
List the case on 5/11/2024.
So as an enable and counsel for
So as to enable Ms.
the-
Nanda Learned Counsel for the appellant to seek instructions.
Item 37.
Lordship is time. The Lordship has already decided and rejected my grievance. So I have enclosed the copy of the order disposed by the university.
Yes. And counsel.
So you are supposed to file
Fresh application.
no, not fresh application. We had granted you opportunity to take notice by special messenger, but because of the order, so notice was not required to be issued because our observation was that they may dispose of the application within that
I
time.
have already I filed a memo with that order. I am appearing to OP2.
Learned Counsel for the petitioner submits that the application has been rendered in as in the meanwhile, the respondent number, petitioner number 2 has already
Opposite party number 2.
opposite party number 2
Registered BPU.
registered BPUT has disposed of
Advance by order dated 19 October 2024. 18. 19.
has been disposed of on 19/10/2024. Allowed or what has it done?
No, rejected. We have said we have no authority because the skill and appointment
Rejecting
is
the prayer of the petitioner for lateral entry, or what was the prayer?
lateral entry.
Lateral. Rejecting the prayer of the petitioner for lateral entry into the what course?
In second year program. No. Second year BTech program.
Lateral entry admission directly into the second year program. Full stop. It is open to the petitioner to challenge the said order if so advised. Sorry, give this. The memo along with the order dated 19/10/2024 filed by the Learned Counsel for the petitioner is taken on record.
Opposite pattern. I have filed. OP2. Number 2. I am Tushar Satpathy, is Tushar Mishra. Misra and Satpathy. That is the confusion.
Sorry, filed by the opposite one is taken on record.
Item 38.
My lordships, this is Counsel Deep Kumar Bhanti appearing on behalf of Mr. Kali Prashanna Mishra. My lordships, he is not well. If you could kindly adjourn it to next week.
Hold it tomorrow. Tomorrow.
Tomorrow.
Hello.
You are Mr.
Deep Kumar Bhanti.
On prayer of Mr. K. Mahanti, learned counsel for the petitioner, list the case tomorrow.
Yeah, that is.
Yes. Okay, on day after tomorrow.
I will.
24. Orders Metro. Essentially urgent matter, item number 4.
Please, my lords. Pursuant to lordship's last order, he has been given provisional admission, my lords, in one of the medical colleges, Dreams.
My lord, I am appealing for the OP number 5. OJ, my lord. He has taken provisional allotment letter issued by the Dreams College, my lord. So she will be get final allotment letter on 24th, my lord.
So can we adjourn? Should we adjourn the matter for 24? Remains now.
Yes, my lords, because the lordships, the last order specifically said, unless there is specific allegation against the petitioner, which can justify of his participation in the ongoing counseling, petitioner shall be provisionally allowed to participate. Now he has been allowed and he has been given provisional admission also. Only that provisional admission has to be finalized. That is the only thing which he says, that there is a procedure. So that's
This
it.
is the disposal of writ application.
Yes, my lords.
We normally would not have passed an order. Because he is a student.
I appreciate
so
that.
that his career is not spoiled, we'd pass the order.
Yes,
no further order need be passed.
Yes,
We have provisionally allowed him, given him provisional admission. He's got now in a government college, as per his rank, strictly as per his rank, private college. And if tomorrow there is some upgrading, sliding up, so he might slide up, or he will be confirmed in that seat.
So my lords can record the statement and
What is the procedure?
See, this is an exceptional circumstance. Normally, we don't do it. Only because it relates to career of a young boy. But we are adjourning it to 24th. After 20. After 24th, 25th. 25th is what, right?
No, Lordship may posted to after 25th because cyclone and all that.
Always. This is Friday. Right? We can fix it on Monday.
Monday.
No, there may be
Sorry.
Monday.
Inclement weather.
On Monday.
Yes,
All
ma'am.
right.
28.
4th. 4th to be taken up as the holiday. Top of the list.
Lordship may record my appearance for the OGE.
We are for the NTA matter.
We'll make it clear that
OP file.
OGE disposed of matter, comma, the comma, in exceptional circumstance, comma, as it relates to career of a young student in relation to his or her
Yes, my lords.
his admission to MBBS course.
Yes, my lords.
MBBS or
MBBS.
MBBS course. Comma, we have taken up the issues subsequent to Taken of the matter in view of subsequent developments.
But my lord, my submission will be, is
Alright.
under this investigation of the CBI, my lord. This is the instruction of the NTA.
Item number 1.
Item number 1. There was a direction of this honorable court that government to take a decision basing on the affidavit filed by the Public Service Commission. Then on the last date, I produced an instruction before this honorable court that the government has constituted a committee and they were scheduled to have meeting on 8th to take a decision. That instruction after 8th, what has happened, I have not received. My lords may keep it to next week so that I can produce it by an affidavit.
But now do it fast.
We'll do it.
Well, sometimes we feel guilty of him because his case is very clear.
Yes.
And because of the matter is pending, he is not getting the relief. The petitioners are not getting it.
Madam, are you appearing for the students who have been?
Lordship, we filed an intervention. So we are people who have worked for 5 years now. And
So no, we'll take care of it.
yes, so
Take
yes,
care.
we don't want to be dislodged. 5 years we worked. So
We shall take care of that.
we are only
Any
there just-
tentative decision with the
Yes,
do it.
They must, because the date was
Day after
fixed to
tomorrow, because 8th, long time has elapsed after 8th. Shall we keep it to day after tomorrow?
Let's say that will come next week.
next
The
week so that I
newspaper reports don't show that we will day after tomorrow we will be holding courts.
Oh, sorry. Yes, you are right, you are
So
right.
let's then on Monday, we'll take up.
That's right.
Wednesday, 6th.
Wednesday, all right.
6th
Wednesday.
And I am submitting my response to the affidavit filed by my lord. The copy.
Again, another affidavit.
Yes, he's filed.
Let there be one final affidavit.
Only one affidavit. I have not filed any
Sir,
affidavit.
Let there be
I
one.
have not filed any affidavit earlier.
Only those tables and charts.
Tables and charts.
Okay, okay.
And table and charts I am incorporating in this affidavit.
Very good.
Only.
No, let there be one.
Only one.
Final affidavit be filed.
Only one affidavit I have filed. I have not filed any other affidavit.
Let there be one final affidavit be filed by either of the parties, incorporating all the facts which can be basis for judgment if in the meanwhile the estate does not take any
Oblige on Monday.
positive decision.
Oblige after the
Hope the
state
estate.
itself.
So it's a very clear-cut case. See, it is very difficult to remove them now. And if the posts are again, it is against the law laid down by the Supreme Court that the posts which have not been advertised should not be filled up. But this is an exceptional situation where we may approve that. No, it's otherwise you'll have some.
6th, man.
6th, as jointly requested on behalf of the parties, these matters.
No.
6th.
That week following.
Next week.
30th on 30th. Sorry, I'm sorry. On 30th. 28th, 29th, I have some.
30th.
30th, sorry.
All right.
Item number 2.
May I please, madam? My lord and friend in this case. I had started for today, your lordship. It is basically the amendment that has been made, your lordship, to the rule. And the prayer is that this should be made applicable to the petitioners, as your lordships have decided in a case. Basically, the anomaly was there in the previous rule of the recruitment rule, your lordship, and which was also set right in the year 1992, your lordship. And pursuant to that amendment.
No, where is that judgment? I have forgotten.
My lord, that judgment. Annex of 14, your lordship. 67 to 70. The operative part starts from 69, paragraph 6. in view of the clear stand taken on behalf of the state of Odisha and in view of the said rules 2024, the writ application has become infructuous because at that point, that writ application was before your lordship for adjudication. Therefore, your lordship disposed of the writ application with an observation that the petitioner shall be entitled to the benefits arising out of the amendment of Rule 15 by virtue of the Odisha Forest Service Group B Recruitment Amendment Rules 2024. Similar anomaly was there in the recruitment rule of the petitioners, which was they had agitated in the year 2018 as soon as they joined the ranks, and they were under contempt.
Let them file affidavit.
Well, it is covered by the your lordship's judgment. Same.
Read Rule 9.
It is exactly the same amendment. Your lordships have observed that since the amendment is of explanatory nature, it would be applicable to the petitioner. And the petitioners are similarly situated.
Read. And read it loudly.
One chance we have to grant it.
No, Rule 9.
Yes.
Unless the court sees no sufficient cause to admit the application and rejects it, notice of the application shall be served on all parties to the proceeding to show cause by a date fixed, and where the application relates to any proceedings in or before a subordinate court or authority.
That is the mandate.
My lord.
That they will have to be given a chance to
My
show cause.
Unless we dismiss that.
Unless we dismiss.
My lord, only submission is that your lordship had granted them the opportunity and they had.
Yes. How much time?
Yes. Your lordship may see the rule that at annex.
No, you file an affidavit, we will see. It is not that the writ petition deserves to be dismissed at the very threshold. See, 4 weeks.
Item number 3.
Lordship will be filing a counter affidavit during the course of the day, Your Lordship.
No, I'll file the rejoinder. Lordship may give me 2 weeks time. 3 weeks time.
States that she is going to file the counter affidavit in course of the day after serving a copy thereof and counsel representing the petitioner. On top, Mr. Parijal and senior counsel state that rejoinders shall be filed if a counter affidavit is filed. Stop. Rejoinder may be filed if counter affidavit is filed. Stop. As requested, as jointly requested, list this matter on when?
3rd week November.
3rd week or not.
Great.
19th.
I will give a slip. Mr. Naveen Kumar and others appearing.
Item number 5.
Case, the petitioner has challenged the rejection of the technical bill on the ground that he has been declared as blacklisted. And the 2 items.
In how many cases you have been blacklisted? Again, there is another case.
After, in view of my tender has been rejected, I have participated in several tenders. In 2 cases there. In the second item is something different, slightly different from the first case.
You are in item number?
In item number 5, my lord. In 2 items, the sub items.
2 items.
Yes, madam.
So,
case WPC number 19492.
Yes.
Is something different from 2276.
So, when were you blacklisted?
Blacklisted in the year 2020.
2021 blacklisted.
Yes, my lord. That blacklist, that was on 8/2/2021.
Yes, then
The lordships have looked to challenging that blacklisting, the petitioner has approached this honorable court. The honorable court disposed of the writ application directing the collector to consider. After that, the collector has considered and lifted the blacklisting by order dated 19/7/2021.
yes,
In that order, there was a stigma, though they have lifted the blacklisting, but that has been specific. A category stated that the sales agency shall not participate for providing different categories of manpower on the outsourcing basis on coming next 3 years in Contempt district. That the specification stigma was there. That blacklisting was made by in the district of Contempt, and that order was passed by the
you
collector.
want us to set aside this order.
My lord?
You want us to set aside the order of the.
No, that order was also subsequently challenged with honorable court. Your lordships has set aside the order by order dated 24/7/2024.
Yes.
In that order, your lordships, I am reading this order. That is, in the first writ application, in the both writ application, that order has been annexed. In the first writ application, that is 22764, that is on page 27. The honor approved to page 27.
Which annexure?
Annexure 4. Yes. Page 20. Starts from page 27, that is forwarding letter. The next page 28, the order.
Yes.
The matter is taken up through hybrid mode. The petition in the present petition has put to challenge an office order dated 19/7/2021 passed by the office of the collector and district magistrate Contempt Fulbani, the operative portion of which reads thus. And whereas with regard to the orders of Honorable High Court on 5/4/2021 arising out of WPC number 11313 of 2021, the representation dated 19/6/2021 filed by the above petitioner was examined with reference to the all documentary evidence and not merit for consideration, hence rejected. However, considering the representation of the agency, the award of blacklisted is hereby withdrawn. The said agency shall not participate for providing different categories of manpower on outsourcing basis on coming next 3 years in Contempt district. The security deposit amount is hereby forfeited. The agency is hereby directed to clear up the backlog remuneration payment of Ashok Chandra Barik, DEO, engaged under COVID at Tumudibandha CIC of December 2020 and January 2020. And if any staff payment found to be...
Yes, why is this happening?
In fact, my lord, the word is blacklisted is wooden, my lord. But he was arrested for a period of 3 years.
Oh, all right. I mean, that period is over.
Well, only taking into this consideration, my lord, this application was rejected.
Yes.
Because there is a clause in the bid document, the bidder must not have blacklisted either by tender inviting authority or by any state government or by any organization.
What about our order?
My lord?
What about our order 24/7/2024?
Well, I have taken instruction over phone, only this much, my lord.
Only. So who has given you the instruction?
My lord, the CDMO, my lord, he has also requested me that.
CDMO will be blacklisted.
My lord?
He will be blacklisted.
No,
he will not take any such decision.
My lord.
What is this? The blacklisting order was passed. Thereafter, you withdraw the blacklisting order, and thereafter you again mention that for 3 years he cannot work. Even that period is over. And
No,
you are again.
No, my lord, that is in the Contempt district, my lord.
Yes, yes.
And this is
Contempt
the, my lord, this is the Nuapara district, my lord.
Yes, yes.
And within order is continuing, my lord, that not to participate in the Contempt district.
And what about our order? This order, paragraph 5, what is the effect of this?
Lord, he has requested me to submit that he will file a detailed counter.
Who is he?
My lord, CDMO, my lord, file a detailed counter, my lord.
File detailed counter?
My lord.
1 week time is for the CDMO?
CDMO Nuapara, my lord.
Nuapara to file counter affidavit. List this matter on 1 week. to be taken up within first 5 cases. So stop. The CDMO shall be under obligation to take into account this court's observation in the order dated 24/7/2024, passed in WPC number 40185 of 2021, read with the subsequent order dated 24/9/2024 in the said case. In the in double two. No, in which case? In the light of the court's order dated so and so and order dated 24/9/2024, passed in WPC number 22764 of 2024. Why was this one? No, fine. No, no.
No, just want to clarify.
In this case, but in this one. See, 401.
When the next date fix, the next date.
1 week. Right.
I don't know. I have a.
When was the writ petition filed?
Petition filed on 4/9/2024.
2 weeks. Kartana.
My lord, in the last item, in the sub item, the last passed an interim order not to take a final decision. That order may be passed. That may extend. The item, second item, that order has been passed on 21/8/2024.
In that case also, counter-affidavit has been filed.
In that case, counter filed, rejoinder filed.
All right. This case along with so and so. The interim order shall continue in the meanwhile. Interim order shall continue in the meanwhile.
But the first item, that order may kindly pass. Otherwise, they will take a decision.
Let us see.
Item number 6.
Item number 6, this is a public interest litigation. Lordship, sir, please to grant me time to file, my lord, sir, reply to the same. So I pray, like the last chance, lordship may grant me 2 weeks time to file that counter.
2 weeks. Further time is allowed for the opposite parties to file counter affidavits. What is this LICI? LICI, what is this?
Item 6.
Item
Item 6, my lord.
All right. Yes.
Cess admission item number 7.
Mr. J.K. Rathamal, he is ill today, kindly taken up next week, madam.
Who?
Mr. J.K. Ratha, senior advocate, ma'am. I'm also taken concern.
When do you want?
Next week.
As requested on behalf of the opposite parties, list this matter on 1 week. Yes, something else.
Yes, he has also telephoned me, he is not well.
No.
Some understanding.
He had been to the office and he said that he requires
3 months time frame to deposit. But our office said that financing is available nowadays, so within 30 or 45 days you can deposit.
Do
Yes,
do it.
we have taken
At least if something is ready for you,
No.
you should avail the opportunity.
No.
Yes.
Item number 8.
Please, Lordship. My lord, can you see the last order, my lord, if your lordships can.
ହେଇଯାଇଛି
Compliant.
Yes.
No, my lord.
ଦେଖୁନାହାନ୍ତି ଆଜିକା ଡେଟ୍ ଟା ଦେଖନ୍ତୁ ହେଇଛି ନା ନାହିଁ 21 ତାରିଖ
Yeah.
No, no. Yesterday I talked with my client that.
I am not disputing it.
He's saying today.
My lord.
21 yesterday that has been fixed and it will be sanctioned within 1 or 2 days. That I have given that.
As a compliance affidavit is sought to be filed on behalf of the contemners.
Right.
So let it be done. So this matter on 1 week. In the meanwhile. Just ensure in the meanwhile, not 2 weeks.
By tomorrow, day after tomorrow, it will be paid.
All right, 1 week. Week.
After 1 week,
Item 9.
The 2 weeks time may be allowed, my lord.
I have also taken consent. Possibly call this matter next week or 1 week.
As jointly request.
2 weeks.
Item 10.
In this case, we have filed caveat and.
No. Yes, read of it.
Item 10, sir.
In this case, you have received the copy yesterday night, my lord. For caveat, my lord. For read appeal, my lord. Memo of the read appeal. Kindly take it next week for preparation.
It is stated by and then counsel for the respondents. Testing respondents that copy of the writ petition has been filed, has been served on him only yesterday. Post office seeks adjournment. List this matter on when
29.
1 week after.
29.
2 weeks. 2 weeks.
This is see, interest seniority. Judgments of this honorable courts are there. Admittedly, both of them joined in one date, and I am senior by age. Therefore, as per the law settled by law, I am the senior most person. That is the case.
What he will have to.
Yes, that is next week. Well, first admission.
All right.
No, 29.
Next week.
My lord.
No, next week.
Item 11.
Yeah, please, Your Lordship.
Yes.
My lord,
Where
this
is the order?
Challenge with regards to my lord, the order passed by the Honorable Single Judge affirming the order of the learned ADM, in which it has been held that the
Where is the order? Where is the order?
order, Your Lordship, order to put
What is the date of the order?
15/9. 13/9,
Please come tomorrow.
2024,
Please,
Annexure 9.
please
Case
instruct
35.
him properly tomorrow. Business matter.
Item 12.
Please instruct him properly.
Yes, madam.
In this case, my lord, kindly grant some time to file counter affidavit.
Yes.
Kindly grant some time to file counter affidavit.
Yes. Okay. 4 weeks.
Item 30.
May please, Your Lordship, my lords. Lordship, the petitioner has framed the direction to the opposite parties not to construct the additional school building over the Sarvasatra public land, my lords.
Over
the public land, my lords, which has been registered in the name of a DT, my lords.
Name of?
Name of the DT, my lords, that is religious property, my lords. And yesterday I have filed an additional affidavit. It may not have come to the records, my lords.
What should be there on that land,
My lords?
according to you? It's a PIL. The PIL.
Yes, my lords.
So there is a land in the name of the DT.
Yes, my lords.
Who are you?
My lords, I am a representative of people, my lords, working as a member of Panchayat Samiti, my lords.
You are a member of Panchayat Samiti. What should be done on that land?
Well, there is sufficient for land for school.
No. What? See, there is a land according to you, which belongs to DT.
Yes, my lord.
They are going to construct
Additional classroom.
additional classroom. No one has any objection. You have the objection.
No, my lord.
So we are, and that objection is in public interest.
Yes, my lord.
So what is the public interest?
My lord, so they are going to worship their, my lords.
They are going to.
They are going to worship their every year, my lord. And the gathering in every year, there are thousands of people gather there, my lords, to perform the Seva Puja, my lords. That will be affected. And on Lord's Mercy, I have highlighted.
What is higher public interest? Education or offering prayer?
Obviously, education matters.
Education is
that is adequate place to construct the building.
These are frivolous writ application. Who want us to entertain, then we will, of course, hear you. Pass appropriate.
Well, sir, for while Lord's Mercy only pays 30 minutes.
Let us see who are you. We always discourage this frivolous PILs. So if your case falls into that category, then you will have also to face the consequences.
But the Tahsildar also noticed to demolish the land, Lord's Mercy. Tahsildar had given a public notice to demolish if that will be constructed further, my lord. A building, my lords. Right? That will not be demolished, my lords. That notice has been issued by the Tahsildar, my lords.
Who is constructing the classroom?
My lord, the state administration, sir, my lord, district administration, my lord, video is the operating, the managing the work, my lord.
So then we are going to cancel that referendum.
No, we don't know. So that has been a public notice. I have filed an affidavit yesterday, my lords. See this. Yesterday I have filed this notice. Yes.
Creating detachment from the mother classroom. Mother classroom.
Yes, my lord.
We are of the prima facie view that this writ petition in the nature of public interest litigation is frivolous and motivated. First off, however, in view of the submission made on behalf of the petitioner that Tahsildar, Bari has objected to construction of additional classroom at Nahan Kulasi. What is this? Which school is this? It's a additional classroom in question. We direct the video, direct opposite party number 5 to file a counter affidavit dealing with the averments made in the writ petition. Stop. We make it clear that if we finally come to a conclusion that this application is that the application, this PIL is fabulous. We will consider imposing exemplary cost. Fabulous and motivated, we will consider imposing exemplary cost on the petitioners.
Who are you appearing for?
My lord, I have filed IN number 13,300.
Who are you appearing for?
I'm appearing on behalf of Mr. Sahu, my lord. So I have filed intervention petition on
So
behalf
who
of
is the party in this case?
no, my lords.
Then
No, my lords, on behalf of the my lord's headmaster, my lord. Headmaster of the school.
notice has been issued to the headmaster that he is making construction on server that is some Gochar on Gochar land, and that will be due to be demolished. So you must have received the notice.
What's the I
No,
has
you
been filed.
take instruction. It will come up on that day.
IN number.
Copy of the additional affidavit may be.
Well, it's already filed yesterday, well, it's in the net. I will serve the copy.
Serve this copy.
So, Miss for further work not to be.
The copy to de diya, madam.
Well, no work should be further proceeded with my lords.
No.
I have filed an IA, my lords.
In the meanwhile, the no authority shall object to the construction in question.
My lord, IN number 13,318 minutes. This IA may be listed along with this.
So construction will continue. This is the order.
That will.
All the villagers are also given the representation to continue the construction. Only this
No, villages might give, but if it is Gochar land, construction cannot be done unless it is de-reserved.
Auxiliary minors demarcated the land and
Whatever it is, so that is land is free from that, it is all right. Gochar land.
Well, work should not be continued, my lords.
All right. Yes. 2 weeks.
My lords, so work should not be continued.
Item 14.
No, work should not be continued, my lords.
Don't say that again.
Grant some time to file counter affidavit. Grant some time to file counter affidavit.
Hey, there is a merit.
My lord, you have lots. On 810, your lordship directed to take instruction, my lord.
Okay.
And I instruct them.
4 weeks for that.
My lord.
On 18th of what?
810, your lordship directed to take
8:10.
instruction, my
Okay,
lord.
all right.
Item number 15.
Mr. Ponda, is there any interim order in this? I think there is some interim order. Okay.
Please, the lordship, this is a public petition for public interest litigation. The petitioner have come before lordship for the protection of the right of the students of Baleswar Jilla to utilize their playground meant for them. But the municipality, unauthorized without the knowledge, they constructing a Kalyan Mandap commercial institution over the playground. In this regard, the pupil and the chairman of the school management committee and also the member of Hillside, they have come before
Where is
lordship.
that school?
My lord,
Where is that school located?
their school, the Jilla High School located, this is the adjacent to the playground. In
Which place?
Baleswar, in the middle.
Yes, why, madam? How can this happen? Playground cannot be used for this.
I'll seek instructions.
Seek instructions.
I have filed construction manual.
Let it come.
Status quo.
No question of status quo. Let it come. We don't know.
Yes.
Your lordship, a notice
Yes,
may go to the
I-
executive officer, Baleswar Municipality.
They are separate panel also.
Panel.
So this may take time because they are going to construct, my lord. This is.
Let them construct. That will be demolished. We are sure. that if the construction is, if there is no playground, one.
There is a playground. I have
Mr. Counsel, if there is no playground other than that ground.
not other than. I am
Alright.
giving my undertaking also.
All right, no question of undertaking, we'll
Yes.
see, let affidavit
Yes.
come.
Let affidavit was short that, my lord. Only 1 week because
Four
they
weeks,
should,
4 weeks.
otherwise they may continue. Their
What will
construction.
happen in 4 weeks?
Subject to result, my lord, they also
Subject
pass.
to result is all.
Yes.
Any construction within the meanwhile for the land, which according to the petitioner is the playground for the students of Jilla School, Baleshwar, that is subject to final result of this case.
It's short that may be fixed for.
4 weeks.
Item 16.
My lord, in this case, my lord, on 810 also, your lordship direct to take instruction, my lord. So kindly grant some time so that we'll file
weeks.
instruction, my lord, or
2 weeks further time.
my
The only thing is, your lordships, in this matter, the work order has not been issued to the private opposite party. And we have a very good case, your lordships. And if the work is allotted to us, there will be a reviewing also. And for no
No,
apparent reason.
that they will decide.
Yes, all that I'm saying is that if the status quo can be maintained.
No, if in the meanwhile something happens, you can just make a mention, we will take up. It is
Lot.
not that if we are adjourning the matter for 2 weeks. In the meanwhile, something happens, we will not entertain, we shall entertain.
Lordships.
Let's just as requested on behalf of the state, let's this matter on these.
Item 17.
First, whenever to file counter affidavit. And senior counsel appearing on behalf of the petitioner has submitted that in the news that the work order has so far not been issued. And therefore, direct for maintaining status quo. Stop. Counsel appealing, counsel for the petitioner shall be at liberty to make a mention if in the meanwhile any development takes place requiring this court to pass an interim order.
However, it has been made subject to result of the case in the first. That shall.
Item number 17.
On the petition challenging the order dated 30th. At 10/2023, in which the opposite party number 4 suspended the lifting of sand from the sandbed, Musigam sandbed in the midterm, my lord. The fact is that
Item number 18.
17.
17. Yes.
my lord, the petition is the successful bidder for lifting of the sand from the Musigam sand bed, my lord.
So where is the order which you are?
That is
challenging?
Annexure 5, my lord. Annexure 5, page 31, my lord.
Yes.
In this case, the opposite party number 4 suspended the lifting of sand from the sandbed, my lord.
Yes.
Against the president. That is for some dues are not paid, but that is only the allegation, sir. But according to the agreement, that is.
You give the no due certificate.
I am giving the fact is that the petitioner, according to the agreement, 3,000 cubic metric ton sand will be lifted from the sand. But from the date of the agreement, not a single tractor of sand has been available on that sand bed, my lord. Therefore, initially he has deposited all the dues one for the year first or second year, my lord. 2020, 21, 21, 22. But he has complained, he has written a number of letters to the memorials to the concerned authority that not a single sand has been available. So my dues can be exempted or you verify the concerned sand bed. But not a single, the authority has not verified, not inspection or not give any opportunity to have verified that the sand bed.
Whether sand is not available or the tractor is not available or you don't have the capacity to.
But you are saying no sand is available, so if the operations are suspended, you should not be prejudiced.
Should be happy.
My lord, there is no CTO consent to operate.
No consent.
My lord.
Why have you given?
My lord.
The petitioner has written a number of letters.
And this is also appealable, my lord.
The two.
File an appeal. This is what he is saying. Offer an appeal. And counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with the liberty to prefer statutory appeal under
Regulation 46 of OMC rules.
under regulation 46 of the OMC
Rules 2016.
before the appellate authority.
Disposable.
One day, same day.
No, that is disposable. Stipulated time.
That is the petitioner prefers appeal before the appellate authority, the same shall be considered and disposed of in accordance.
And file with better.
Run counsel for the petitioner, after some argument, seeks permission to withdraw this petition in view of certain developments said to have taken place subsequent to filing of the present writ application. This writ application is accordingly dismissed as withdrawn with a liberty to the petitioner to challenge any action taken by the opposite parties subsequent to filing of the present writ.
Item 19.
This is a contradiction.
Yes.
This is
Who is for the other side?
not, it's the state and office of the accountant.
Accountant general.
What is the order?
If I may place the relevant portion from, at the order starts from page 12. And this was a writ petition in form of a PIL filed for investigation and inquiry into some irregularities in a school in Cuttack, my lord. It was a writ petition filed for praying for an inquiry and investigation.
So where is the order?
My lord, order is at page 12. Annexure 1, my lord. The order starts from page 12.
What is the direction?
My lord, the relevant portion is at page 13, para 6. I read it out, my lord. Having heard learned counsel for the parties and after going through the records, it seems that the grievance made by the petitioners with regard to the conduct of the headmaster has been meted out as both departmental as well as criminal proceedings have been initiating against him, and since the charges leveled against him have not been proved, both the proceedings have been dropped. So far as the allegation of irregularities of school funds is concerned, it appears that on basis of the audit AG, certain deficiencies have been pointed out, and such deficiencies have been meted out by subsequent headmaster by submitting complaints.
AG has no role.
But the direction.
AG does not do anything.
Lord, the direction of this honorable.
Where is the question of direction? AG does not do anything. AG just has a duty to make an audit and submit that to the government. The government that is placed before the assembly, and that's all.
My lord, let me just.
Nothing can be adjudicated.
The subsequent paragraph, your lordship. Just the subsequent paragraph, my lord. In view of the matter, at page 14, my lord. In view of the matter, since the AG has already taken into consideration the reply submitted by the subsequent headmaster with regard to the alleged irregularities of school fund by the previous headmaster, and the matter is pending for adjudication, this court directs the Accountant General of Odisha to examine the same and pass appropriate order in accordance with law. This is the order passed by this honorable court.
All right. So the direction was to the AG. And you want the departmental secretaries to be punished. Huh? AG was a party. Office of the AG was party in the writ petition.
In the writ petition.
The petitioner in the present contempt application has alleged disobedience of an order of this court dated 1/12/2023 by the Accountant General GSSA, Odisha, Bhubaneswar. First off, he has been pleaded in his individual capacity as opposite party number 1. The opposite party number 1. So next, the Office of the Accountant General was not included as opposite party in the proceeding. First off, in such circumstance, in our opinions, no case of disobedience of this court's order is made out by opposite party number 1. First off, next, be that as it may, it appears that in the light of this court's order, the Accountant General has sent certain communication to the, who is that? Arun Kumar Sethi, who is he?
There are two petitioners.
To the principal, who is principal? To the petitioner as regards the steps taken. First off, no case of deliberate disobedience of this court's order is made out. Contempt petition is dismissed. Yes, grateful.
For admission, item 39.
For the petition, some time given to file rejoinder. Counter has been filed by OP6 on dated 23/9/2022.
It is stated by. How many years will you take? When was the counter affidavit filed?
Affidavit 23/9/2024.
24. And counsel for the petitioner seeks adjournment to file a rejoinder to the counter affidavit file of the opposite parties. Top as requested, let's this matter on when? When?
2 weeks.
2 weeks.
Counter has been filed by whom?
By petition.
Rejoinder on record.
OP number 6, my lord, filed. I'm for the petitioner.
Item 40.
In item 40, my lord, before my learned senior starts, my lord, I pray next week because I have not prepared in this case. I have taken consent of my learned senior.
Taking consent doesn't arise. I never object to any action.
I have requested.
But this should be the way that before making a mention for adjournment, the other side should be informed.
I never object
minimum
to any adjournment on the ground of inconvenience of lawyers.
As requested by Mr.
But may I pray that it may come on either 29th or 31st. And your lordship may fix it at PM because it is the court manager's case. It will take some time.
Be fast holiday.
29. 29 at 2 p.m.
Pardon, my lord, item number 39, my lord. I missed the list. I was in the backside. My learned friend has taken time to file rejoinder, my lord.
But rejoinder is already
Basically,
there.
my lord, we have supported the government, the counter they have filed. We are supporting. I am for the opposite party number 6, my lord. Week time may be given. because of my lord, due to pendency of the writ petition, my lord, we are unable to take out the sand, my lord, and the lease will be expired in the year
But he has a right to
2025.
file a jointer.
Few months is left. 1 week time, my lord, maximum.
2 weeks. 1 week time.
1 week time is enough because I have served the copies, my lord,
1 week, all right.
a month back. Date may be fixed, my lord.
All right, date you will get, Mr. Now.
Grateful, man.
Item number 41.
41, my lord, I'm sorry. Yesterday it is in the list I could not appear. My lord, there is a application for, I am for the respondent number 1, that the contesting respondent. The IA is there for condonation of delay. I file objection, only 1 week time may be allowed.
How much?
16 days.
16 days delay we are controlling. Delay control. Yes, let us come on, Mary.
Some black surface that.
Where is the order?
The order that is that annexure to page 19. Passed by the Honorable subject matter of challenge. The Honorable Single Judge allowed the writ petition on the very first day. And the issue like this, my lord, the caste certificate issued by the Tahsildar in favor of OP number 1. Caste certificate issued by the Tahsildar.
Item 41.
Item 41.
Are you sure it has been disposed of on the first day? Because parties have appeared. That is paragraph 1, not order 1.
Natural justice, the only ground which is taken. That is why, sorry.
All right. No problem.
Sir. The caste certificate was issued by the Tahsildar in favor of the respondent number 1. That caste certificate was challenged by the respondent number 3 before the sub-collector in an appeal, that is miscellaneous appeal bearing 1 of 2019. But although the OP number 3 is an outsider, no way connected with the caste certificate, but she challenged only on the ground, respondent, she challenged on the ground because the respondent number 1 was selected for the post of Anganwadi worker. So that was the issue basing on which she challenged the caste certificate, alleged that the respondent number 1 is caste, is Gouda by caste. However, she has obtained a certificate of scheduled caste, that is Tala, from the Tahsildar.
What is the spelling?
TANLA, Tala. That is scheduled caste category. So that appeal was preferred before the sub-collector. Now the sub-collector allowed that appeal and set aside the order of the Tahsildar. That challenged by the respondent number 1 in the writ petition, alleging that instead of the state level caste certificate committee, as per that judgment, the sub-collector is not empowered to declare the certificate as illegal. So also a point was raised that as per rule 1980, the appellate authority is the collector, not the sub-collector. So at the behest this sub-collector, the order passed by the Tahsildar could not have been set aside. Now that 1980 rule, that was subsequently amended.
amended, that was subsequently repealed, and a new act was formed in 2012. And so also to carry out the provisions of the act, a rule was framed. Even as per that rule, the collector is the competent authority to entertain the appeal. But that act, it was argued that never came into force because there was a provision in the statute that it shall come into force from the date appointed by the state government. So that subsequent notification of appointment never published in the Gazette. So the act, once the act has not come into force, so the rule to carry out the provision of act is also not permissible. So that is the reason and how the has intervened, and the Honorable Court has passed an order that either be it the old statutory provision, 1980 rules, or the new statutory provision, the collector is the competent authority to entertain the appeal, not the sub-collector. That is the only ground basing on which the writ petition has been allowed. So
what is wrong in the reasoning? The 2012 Act cannot apply.
Yes.
Since it was the appointed notified.
Yes.
So there cannot be any legal infirmity in that finding, if that is the view which has been taken.
Yes.
If 2012 goes, then we come to 1980.
1980 also the competent authority is the
collector.
1980.
Is the collector.
That is what I have explained yesterday also. Lordship, we have a glance to Rule 6 of the 1980 rules.
80 or 89?
1980. That is Odisha Caste Certificate for Scheduled Caste and Scheduled Tribe Rules 1980. So Rule 6 is the competent authority who can entertain the application for issuance of the caste certificate. That is district magistrate, collector, additional district magistrate, subdivisional magistrate, executive magistrate, revenue officer not below the rank of Tahsildar.
Rule 8.2 says that subsequently on verification it appears false averments have been made, that same authority can
Same authority can cancel. And your lordship may kindly see 9.
Just one moment.
Nine.
So this who you said has cancelled? Sub-collector. Tahsildar has issued the certificate.
Tahsildar issued the certificate.
Cancelled by
appeal preferred by respondent number 3.
Before
the sub-collector. The sub-collector cancelled.
The sub-collector did not have any jurisdiction. That is there cannot be any dispute over this.
Yes.
I hope it is not the case that the High Court directed the party to appear before to file appeal before the sub collector, because sometimes we pass orders
No.
saying that you file this before.
No.
That was not the case.
So this appeal has been filed, but fairly I would admit that
Okay.
the statutory provisions are otherwise. Even under the new rules also, it is the sub collector is the
New rules
collector.
cannot apply.
New rules cannot. And even if the new rule is applied, the act is applied, then the corresponding rule says it is the collector, even if it is applied.
And what about the parties, private parties?
So private parties, my learned friend is appearing for.
I am appearing for the opposite party number 3.
Huh?
Opposite party number 3. My lord, wrongly I filed the appeal before the sub collector, but in the meantime I filed appeal before the collector. That is number misapplication certificate appeal number 1 of 2022.
1 of
2022.
which is pending.
Which is pending, my lord.
The of Odisha. I heard and so and so. The state of Odisha has preferred the present intra-court appeal to challenge an order passed by the single judge of this court dated 4/1/2023, passed in WPC number 15048 of 2022. Stop. So 2020. This appeal is barred by limitation. First off, there is delay of how many days?
16 days.
16 days. 16 days in preferring this appeal. Stop. Considering the government's met in the application seeking condonation of delay, comma, the delay stands condoned. Stop. The short fact necessary for the present adjudication are that the respondent number who had filed the writ petition, respondent number?
Respondent number one.
Respondent number 1 had preferred a writ petition before this court, giving rise to WPC number 548 of 2021, challenging an order dated 8/10/2019 passed by the sub-collector Nayagarh in miscellaneous certificate appeal case number 1 of 2019. Stop. By the said order dated 8/10/2019, comma, exercising power of an appellate authority under the Odisha caste certificate bracketed for scheduled castes and scheduled tribes, comma, rules 1980, the sub-collector had cancelled the caste certificate issued in her favor. So stop. The order of the sub-collector was passed on an appeal preferred by opposite party number, respondent number 3. Number 3. So stop. The said order of the sub-collector was challenged before the learned single judge, before this court, by filing the writ petition mainly on the ground that the sub-collector did not have the jurisdiction to act as an appellate authority. Stop. And single judge has sustained the said ground for challenge to the order of the sub-collector and set aside the order, comma, by the order which is impugned in the present intra-court appeal. So stop. We have heard also. Stop. We do not find any legal infirmity in impugned order passed by the learned single judge in view of the clear provision under the rules of 1980, which Rule 9 of which confers Rule 9 of which provides that any person aggrieved by an order passed by the competent authority subordinate to the magistrate/collector may prefer an appeal before the district magistrate/collector concerned. So stop. And single judge, comma, in our opinion, has rightly held the order passed by the sub-collector dated so and so to be beyond jurisdiction. So we have been informed that
Mr. Patnaik, Jagamohan Patnaik.
what is
My
the
name is
name of
Prithviranjan Behera.
2012
Prithviranjan
Act?
Behera. JR Behera.
2012. What is the name of 2012 Act?
That is Odisha Scheduled Caste, Scheduled Tribe,
Yes.
and Backward Classes Regulation of Issuance. This is the act and this is the corresponding rule.
We have been informed that the Odisha Scheduled Caste, Scheduled Tribe and Backward Classes bracketed Regulation of Issuance and Verification of Caste Certificates Act 2011 bracketed Odisha Act 8 of 2014 bracket close has been enacted. Subsection 2 of Section 1 of which prescribes that it shall come into force on the date as the state government may, comma, by notification, comma, in the official gazette, comma, appoint. Or stop. In exercise of rule-making power, the government has framed rules in the name of scheduled tribe and schedule, where is that? Odisha Scheduled Caste, Scheduled Tribes and Backward Classes, bracketed Regulation of Issuance and Verification of Caste Certificates, Rules 2019. Stop. The single judge has noted in the impugned order that there is no notification of the date published in the official gazette from which the act was to come into force. And in such view of the matter, Rule 2019, the rules of 2019 had no application. Stop. In any view of the matter, comma, even in terms of, even under the even the provisions under the rules of 2019 confer power of the appellate authority on the collector and not the sub-collector. So, next, since the respondents, since the appellants could not satisfy in the writ proceeding that the state government had notified a date in official gazette from which act was to come into force, learned single judge has rightly held that the provisions of the act were not applicable. So this is what the learned single judge held.
Yes.
Yes. Full stop. Accordingly, we do not find any merit in this appeal. It just stands dismissed. Those who are learned counsel appealing on behalf of respondent number 3 appeal before the sub-collector. Sub-collector has submitted that in the light of the court's order, the order passed by the learned single judge, he or she has preferred an appeal before the collector Naigad. Collector Naigad, registered as also appeal number 1 of 2022. So it is expected that the collector Naigad will decide the appeal of respondent number 3 in accordance with law without being prejudiced by the earlier order passed by the sub-collector or a sub-collector on its own merits. We have no observation of the car. No, not even here.
So set aside only on that ground.
Yes, Mila.
Because lack of
Jurisdiction.
Had you been granted liberty to file appeal?
Appeal already filed, Mila,
No,
before
no.
the collector.
By the learned single judge, was there any reference or you filed it subsequently?
Prior to the order of the learned single judge.
Item 42.
May I please, Your Lords? I will need to place the debt settlement and for the appellant.
First place the order.
My lord. Impugned order is at page number 22, my lord. My lord, annexure 1 starts from page number 16 and the operating part is at
Annexure 1.
Annexure 1. Starting from page number 16, my lord, operating part is at page number 21. Para 6. In view of the same, this court, while disposing the writ petition, direct the opposite party number 2 to take a decision on the grievance raised by the petitioner and directed by the in its letter dated 12/4/2018 under Annexure 8 series within a period of 2 months from the date of receipt of this order, my lord. While direction was issued to the opposite party number 2, consider the representation of the writ petition under Annexure 8 series. My lord, that is page 188. This same representation has been annexed in another writ petition, that is my lord WPC OSC number 2350 of 2018,
as at Annexure 4 series, and that writ petition has dismissed as infructuous, my lord. That is at page number 235, my lord. Page number 235, my lord. The self-same representation has been declared infructuous by this honorable court in another coordinator of May, my lord.
Challenging the order directing the opposite party to take a decision.
No, my lord.
Then?
Interim order is there, therefore they have not taken any decision.
No, but which order are you challenging?
I am challenging Annexure 1, my lord, page 21.
Yes, so there is an order to opposite party number 2 take a decision on the grievance of the petitioner.
Under Annexure 8 series.
Huh.
8 series has already been annexed in another writ petition, that is WPC OIC number 2350 of 2000. The self-same representation has been annexed in that writ petition, and that writ petition has been dismissed as infructuousness. Then the writ petition is infructuousness, that representation, which on the statement, my lord, kindly see Annexure my lord, page 235.
235 or page 35?
235, my lord.
What was that previous?
My lord, it is contended by that
Just
by
one moment, please. What is the number of that where it was declared to be infructuous?
my lord, WPC OIC number 2350 of 2018. My lord,
So many writ petitions.
so many writ petitions has been filed, no certificate has been given, and no explanation has been in the writ petition, my lord. My lord, kindly see page. Page 97, my lord, kindly see the certificate given in writ petition.
Yes, so what happened to this 12/4/2018?
My lord.
What has, according to you, the grievance has become infructuous?
Yes, my lord.
Where is that?
My lord, the self-same representation, the Annexure 8 series. My lord, kindly see the Annexure 8 series of the writ petition. That is, my lord, page 188.
Who are you? You are a respondent.
I am opposite party number 5 in the writ petition, and now I am appellant in this appeal, madam.
So how does how you are affected by this order?
My lord.
How are you affected by this?
My lord, numbers of writ petition has been filed. Suppressing this fact, the present writ petition has been filed after 4 done, my lord. Selection, the main crux of the matter, my lord. Therefore, I may be permitted to place the date chart, my lord. Appendix B. My lord, advertisement number 17, my lord, Appendix B to the appeal of 2015-16 was issued by the OPSC, opposite party number 2.
You are reading date chart.
Yes, my lord. Appendix B.
Yes.
To kill up assistant professor in dentistry of Himsar, Burla, my lord. 13/7/2016, the OPSC opposite party number 2 published the merit select list where the appellant placed at serial number 1 and respondent number 6 was placed at serial number 2. 3/11/2016, appointment order was issued by the government, which was accepted by thereby both the appellant and the respondent number 6, and they are joined in their respective post, my lord. 36/2017, respondent number 6 challenged the said merit list by filing WPC number 12918 of 2017. In the third writ petition, the respondent 2, the OPSC and the present appellant have filed their respective counter-affidavit, and the appellant also filed his rejoinder affidavit. Thereafter, on 18/7/2018, respondent number 6 filed WPC number 12602, another writ petition, my lord, of 2018, with a prayer for direction to the OPSC as well as government to consider his representation, which has been filed relating to the self-same selection, my lord. On 21/8/2018, When the matter was ready for disposal, the petitioner withdrew the writ application bearing WPC 12918 of 2017, which was dismissed as withdrawn without providing any liberty. On the same day, at the stage of fresh admission, another writ petition, WPC number 12602 of 2018 was withdrawn with liberty to file representation before the appropriate forum. 27/8/2018, with the self-same prayer as made in WPC number 12918 of 2017, the petitioner filed an original application before the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, which was provisionally registered as P number 218C of 2018, since delay in filing defective one. On the same day, another OA has been filed, that is numbered as OA 23506 of 2018, for a direction to the government to consider his representation relating to self-same selection matter. 2/8/2019, Odisha Administrative Tribunal was abolished. Though almost 1 year was elapsed, no steps were taken by the petitioner for hearing of these cases before the learned tribunal. 10/1/2020, WPC number 127 of 2020 filed for transfer of E number 218 of C of 2018. Thereafter, my lord, WPC number 1279 of 2020 filed for transfer of OA number 2350C of 2018. WPC number 1277 of 2020 and WPC number 1279 of 2020 were disposed of by permitting the petitioner to move an application before the registry of tribunal for transfer of both the cases to this honorable court. 13/11/2020, WPC number, the present writ petition which has been challenged in this appeal matter, 3/1/2020, was filed with self-same prayer as made in the WPC number 12918 of
And
2007.
these facts were not disclosed in the writ petition.
Yes, my lord. Therefore, in support of this claim, I am citing two judgments, my lord.
What do you do?
My lord.
What do you do? Or presently, what are you doing?
Assistant professor. Assistant professor. The question is, my lord, the only issue is.
The only issue is, why did you not disclose all these facts in your writ petition?
I'm submitting, my lord.
Whether you disclosed or not.
My lord, I'm submitting.
Whether you disclosed or not, yes or no.
Yes, my lord, I'm submitting.
You say, please, yes or no.
I'm
Whether
finding the documents thereafter, only after I find that thereafter I can.
So you will not say yes or no.
Yeah,
So you are
we have not suppressed anything.
So we are again putting the same question.
My lord.
Did you disclose in the writ petition
That is disclosed.
about filing all those writ petitions? Yes or no?
Your lordship may kindly turn to page 97.
We will not turn to unless you say yes or no, whether you had disclosed.
We have given disclosed it.
Disclose. Yes, say yes. What is wrong in it? Yes, which page?
Page 97.
Page 97 of the writ petition.
Running page 97 of the topic.
That was the last writ petition.
Last petition.
My lord.
You're not supposed to mention previous ones.
We were not
This is the past. May I pardon to explain?
Yes. Let him conclude.
In this court, my lord, I am submitting to judgments of the Honorable Supreme Court suppression of facts, my lord. Para 6. A fresh writ petition was page 2, my lord. A fresh writ petition was filed. The same has been dismissed by reasons of impugned judgment, holding that the appellant have suppressed the material facts. Filing of 4 writ petition on the same cause of action, and thus it was not maintainable. Appellant are thus therefore before us. My lord, thereafter I would like to draw your lordship's attention, page 4, para 15 and 16, my lord. A writ remedy is an equitable one. A person approaching a superior court must come of clean hands. It not only should not suppress any material facts, but also should not take recourse to the legal proceeding over and over again, which amounts to abuse of process of law. For the reasons, appeal which is dismissed accordingly with cost.
Yes.
And thereafter, second judgment at para 32, my lord. It is thus clear that though the appellant company had approached the High Court under Article 226 of the Constitution, it had not candidly stated all the facts to the court. The High Court is exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution. Over and above, a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must place all the facts before the court without any reservation. If there is suppression of material facts on part of the appellant or twisted fact have been placed before the court, the read court may refuse to entertain.
All right.
Thereafter, my lord, my 2 contention petition is not maintainable on the ground of delay because the selection was made in the year 2016 and he has filed the present writ application in the year 2020 after 4 years. The rules provides, my lord, the validity of the selection list is 1 year, my lord. That is at, my lord, at page, my lord.
No, but that we are not required to go into.
My lord.
When single judge has done nothing. When single judge has just said that consider.
Yes, my lord, after filing of the representation, filing of the counter by both opposite party number 5 and the OPSC. Thrice, OPSC has filed their counter in the first writ application, my lord, 12918 and thereafter in before the
We are
learning.
not required to go into the merits. Yes. Why did you not disclose?
My lord, this disclosure has been made and the previous lawyer, Dr. Ashok Mahapatra is dead. We cannot examine all those issues. Dr. Ashok Mahapatra. Again, Dr. Ashok Mahapatra.
How can you argue this?
No, I am not. That is why
Just tell us how much cost.
as your lordship deemed just and
How much cost?
your lordship.
This amounts to suppression of material facts. Hmm?
That will be decided on merit subject to payment of some cost or something like that. Because your lordship can apply.
On merits, we will go into that aspect only. If there is suppression of fact, we shall not go into further merits. We will decide on that basis.
I am explaining that. If your lordship permits, I will be explaining suppression cost.
Either you are appearing for whom?
We both are appearing in the case of the only party.
Either of you can you argue?
That is the
Both of you.
That is how I sought permission. Anyway, my honor friend.
As you wish. You decide.
Let it be decided on merits, my lord.
Yes, we are there to decide on
The
merits.
writ petition.
We are here to decide on merits. First of all, you decide on merits, so we'll argue first. Or who will argue?
You.
Your lordship will not argue.
My lord. Yes, he, my friend, I have engaged him in this case, my lord. Because I am personally involved in the case, that is how I represent him. The interview was held for the post of May submit.
Mr. Counsel, that we are not required to go into. One single judge has just disposed of the writ petition.
Yes.
With a direction to consider.
Dispose of the representation.
Dispose of the representation, nothing else. Now the question is, because of suppression of fact, even such order could not have been passed. That is the question. We shall not go into the merits. If we are satisfied that you had not suppressed any fact, then we will allow the order to sustain.
The question is, my lord, that we have given the last writ petition that was before this honorable court. And if your lordship allows that a cost be imposed and let the single judge decide the matter, I will not go beyond that.
And we will dismiss the writ petition.
Then I may be allowed to make a submission on merits of the case.
No, on merits we will not hear you because you are not entitled. Not entitled to be heard on merits because of your conduct. And you are entitled to, other it is, you are required to pay cost also. And such cost that next time you don't repeat the same thing. You must understand that every time when you file a writ petition, you are required to disclose what you had done earlier.
May I pray?
Merit, there is no question of merit.
No, may I pray? On the subject, your lordship said that yes, whether suppression, can it be adjourned? I will not.
What not? The writ petition is a, can you go?
No, not on writ petition. Regarding suppression of fact only.
Suppression of fact?
My lord.
What?
Whatever cases have been there, whether I knew there, whether I have suppressed, that is why I give a detailed note. Your lordship will decide. Only on the issue of suppression of fact.
Learned counsel appearing on behalf of the petition appellant has argued assailing the order passed by the learned single judge that the respondent / writ petitioner had pressed material facts as regards filing of various writ petitions prior to the writ petition in hand. First off, he has relied on Supreme Court's decisions in case of MS Prestige Lights Limited and also reported there also citation. And Udaini Gramadyog also reported in so to submit that the writ petition was fit to be dismissed on sole ground of suppression of material facts or regarding filing of previous writ applications. So, next learned counsel appearing on behalf of the petitioner has argued that non-disclosure of filing of previous writ applications does not amount to suppression of material facts. This is your submission.
Would not. My lord.
No.
Will not amount to suppression.
Of material facts. So he seeks adjournment to address this court on this point. Is this matter tomorrow? Yes.
Madam, just take
Tomorrow.
no, tomorrow, madam, it will take time, sometime. Sometime may be done.
Sorry.
Next week, madam, next week. Next week.
Monday.
Madam.
Monday.
For respondent number 4, my lords.
Lords, I'm for the petitioners, man.
Yes, please make your submissions.
Please, my lords. Lords, in this case, we have challenged the order of the learned single judge on the ground that the learned single judge has allowed the writ petition with reference to the old law, that is section 39, 1 and 6 of the Insurance Act.
39,
1 and 6, subclause 6 of the
39.1 and 39.6
yes, 39.1 and 39.6
of the old act.
Of the old act, unamended act, my lords. And the judgments passed by the Honorable Supreme Court with reference to the then existing law, 39, 1 and 6. Whereas the law, section 39 had undergone an amendment in the year 2015. And the learned single judge ought to have considered and given the finding and effect of and decided the list on the basis of the new law, not with reference to the old law.
This point has been decided by this court. I remember this point was this issue was heard by me.
Similar matter, lordships were in session of this, lords.
This matter.
In this matter,
and
yes,
10th,
yes.
your lord.
Yes, my lords, before issuing notice, the Honorable Court. Yes.
No,
So,
I
my lords,
must clarify, my lord. This is a point which is coming up before various high courts. And this is something which requires a lot of
no, it has already come before the a number of high courts, and I have filed a convenient compilation for the assistance of this honorable court, and there are conflicting opinions, and I would like to distinguish those judgments also. So my submission is, my lord, the learned single judge has not given any finding on the amended act as to why this act is not applicable to the facts and circumstances of this case. Let's kindly have the finding at page 17 of my writ appeal. Page 17, my lords, may kindly have. I have annexed the impugned order. My lords are there?
Yes.
But the learned single judge says, and in para 4, court's reasoning and analysis heard the learned counsel for the parties peruse the documents presented before the amendment 2015 Insurance Act. Concept of beneficial nominee was introduced into section 39(7). As per this provision, the event that the holder of an insurance policy nominates their parents, spouse, children, or any other family member during their lifetime, the designated nominee shall be beneficially entitled to the amount payable by the insurer. This is applicable unless it is proven that the policyholder was not legally capable of conferring such a beneficial title upon the nominee. And then the learned single judge straight away goes to Sarvati Devi and Usha Devi's case, which holds that, in which it has been held that nominee is only the hand, he is only the agent, he is not beneficially entitled to the proceeds of the insurance policy. So this was the ratio of the, and the learned single judge and the Honorable Supreme Court in that case has laid down the law. And Mallards may kindly have my compilation if the Honorable Court wants to have the ratio of Sarbati Devi. And it is otherwise, it is now was holding the field till the amendment of the Act in 2015. So this was the judgment holding the field and governing the law of disbursement of the policy. And then the learned single judge proceeds to mention the case of Indrani Wahi versus Registrar of Cooperative Societies and others. Second judgment has been relied upon, Indrani Wahi, but my lord may kindly say Indrani Wahi, if my lord is having, has been passed in the context of the West Bengal Cooperative Societies Act, and not in the context of the section 13.
We have understood, Mr. Parasar, that
please
those the judgments are not post this 2015 amendment in the Act.
No, Indrani Wahi.
Not with reference to the provisions under 2015 amendment.
Please, my lord. No, Indrani Wahi is after 2015, but that has been passed in a totally different facts and circumstances. That is with reference to the interpretation of Section 79 of the West Bengal Cooperative Societies Act, and the issue of 39 of the an insurance policy was not involved at all, although reference has been made.
Right.
So my lords may kindly see, then after this amendment has come into existence, if I am permitted to read the provisions of amended 39(7), I can, please, I may be permitted.
39,
my lords. My lords, 39 up to section 6, the old sections have been retained. From subsection subclause 1 to 6 have been retained as it is.
Yes.
And the new section has been introduced, that is section 7. Instead of the old section 7, now new section has been introduced, which says, subject to the other provisions of this section, where the holder of a policy of insurance on his own life nominates his parents or his spouse or his children or his spouse and children or any of them, the nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under subsection 6, unless it is proved that the holder of the policy, having regard to the nature of his title to the policy, could not have conferred any such beneficial title on the nominee. So, this has carved out an exception in favor of certain types of nominees, that if these persons are made nominees, then they will be beneficially entitled to the proceeds of the insurance policy after the death of the policyholder. And this has been further, by the legislature has been further confirmed in subclause 8, my lords, which further reads, subject as aforesaid, where the nominee, or if there are more nominees than one, a nominee or nominees to whom subsection 7 applies, die after the person whose life is insured, but before the amount secured by the policy is paid. The amount secured by the policy, or so much of the amount secured by the policy as represents the share of the nominee or nominees so dying, as the case may be, shall be payable to the heirs or legal representatives to the nominees, or the holder of the succession certificate. So, my lords, here again, the legal heirs of the nominees have been given the right, not the legal heirs of the deceased policyholder. So, it further clarifies the intention of the legislature that once this exception has been carved out in favor of these nominees, and if those nominee or any of them dies, then in that case, the legal heir of the nominee or nominees so made, they would only be entitled and not the legal heirs of the deceased policyholder. Then subsection 9 also strengthens the same proposition. Nothing in subsection 7 and 8 shall operate to destroy or impede the right of any creditor to be paid. No, sorry, this is not applicable. 10, let me kindly read. Provisions of subsection 7 and 8 shall apply to all policies of life insurance maturing for payment after the commencement of the Insurance Laws Amendment Act 2015. So this is a clear-cut direction law laid down by that. It would apply to all.
Do you have the gazette notification of this 2015 amendment?
Yes, my lord. That is not in dispute and that is not doubtful. It is there. It is there with me, and it is not in doubt, my lords. Although it is not placed on record, but it is there, my lords. It is published in Extraordinary.
Do you have a copy, Mr. Mishra, of this? I have a. We just want to see the objects and reasons.
Please, my lords.
So
for the please, yes, my lord. So far the objects and reasons are concerned, may I submit to the Honorable Court that this amendment was undertaken by the Parliament in view of the recommendations of the Law Commission.
This is what he was making. This is their oral submission. We want to see.
Would you like to see? I have a copy of it. It's on the mobile, my lord, if you love.
Yes, sir.
I have the Law Commission recommendations also, which were there. Let my friend complete then.
Yes.
Please, my lords. My lords, may I proceed, or the Honorable Court would like to go through that the gadget notification? Because it is...
After recess, we will take up.
Please, my lords.
Give us a copy.
We have got copies.
Yes. Yes, Mr. Parasha. Please unmute yourself, Mr. Parasha.
Please, yes, my lords, I have unmuted. Am I audible, my lords, now? Am I audible, my lords?
Yes, now you are audible.
Please, my lords. My lords, may kindly see this gadget notification. My lords, a number of sections have been amended with this amendment, my lords. And
the objects are not mentioned.
Objects are not mentioned. Yes.
All right, we will see.
Please, my lord. So now, secondly, my lords, may kindly once again have the reference to subsection 11 of the amended act, my lords. Subsection 11 also shows the intention of the legislature. Subsection 39, subsection 11. My lord is there.
Yes.
My lord, it says that where a policyholder dies after the maturity of the policy, but the proceeds and benefit of his policy has not made to him because of his death, in such a case, his nominee shall be entitled to the proceeds and benefits of his policy. Again, my lord, the intention of the legislature is reiterated and confirmed with all these amended sections which have been inserted. So, my lord, now this, even after the amendment, the Honorable High Courts have interpreted, and there are judgments which I have filed a compilation for the assistance of my lords. If I can take the Honorable Court through all these judgments, I have tried to track the history of the interpretation of section 39. After Sarbati Devi and after the amendment.
Yes.
Please, my lords. My lords, before proceeding, my lords, I would like to place before the Honorable Court as to this amendment was carried out as per the recommendation of the Law Commission, my lords. And what were the recommendations which reflects the concern of the Honorable Law Commission? It is at page 59 of my compilation. My lords, I have given a compilation of the judgments. My lords, may kindly have that. That has been extracted by the Honorable Delhi High Court for the first time in its judgment. My lord, is there?
Yes. Where? Which page?
Page 59, my lord, sir, running page 59.
Of your compilation?
There are 30. Please, of the compilation. Judgments compilation. Filed by me. Shweta Singh Huria versus Srimati Santosh Huria and another.
Yes.
In this judgment, the Honorable Delhi High Court for the first time took note of the recommendation of the Law Commission. Para 30 says Section 39 was amended by the Amendment Act 2015 and was pursuant to the recommendation of 190th report of the Law Commission of India, relevant passages from which are as under. Law Commission's view. Then this says the view, and then it further says the last paragraph, although it is true that this is the law in USA, Canada, and South Africa, the social realities of our country, where the death of a sole breadwinner of the family immediately throws the remaining family into hardship, cannot be lost sight of. To deny such instance, the right of the legal representatives to the policy amount on the basis that the nominee is a different person seems harsh. On the other hand, what appears reasonable is to give an option to the policyholder to clearly express whether the nominee will collect the money on behalf of the legal representatives. In other words, such nominee will be the collector nominee, or whether the nominee will be the absolute owner of the monies in which case, such nominee will be the beneficial nominee. Public interest and the peculiar social realities in India cannot permit the adoption of the procedures followed in Canada, USA, and South Africa. The Commission is not agreeable to the suggestion that a provision similar to Section 45 ZA as in the Banking Regulation 1948 should be adopted. The suggestion that a provision be added to make the nomination effectual for the nominee to receive the policy money in case the policyholder dies after the maturity of the policy, but before it can be encashed, has also been welcomed by the responses and is hereby recommended. Then my final recommendation of the Law Commission in regard to Section 39, which are then summed up in para 7.1.14 and 7.1.15. I take the Honorable Court to the last paragraph at the bottom of page 60. May I read, my lords?
We have read.
Please, my lords. Then, my lords, at next page, page 61, my lords, may kindly have 31 also, paragraph 31 also, please. As is evident from the reading of the recommendation of the Law Commission, a distinction was carved out between the beneficiary nominee and the collector nominee, and Section 39 of the Insurance Act was amended accordingly, adding subsection 7. Beneficiary nominee means a nominee who was entitled to receive the entire proceeds under an insurance policy, and a collector nominee means a nominee other than a beneficiary nominee. Keeping this distinction in mind, subsection 7 of Section 39 was carefully and cautiously drafted, and the words used by the legislature are beneficial interest. So much the Honorable Legislature has not used the words and the terminology of beneficial nominee and collector nominee, but the Legislature has used the term beneficial interest in Section 39(7).
Yes.
Which the Honorable Supreme Court in Sarbati Devi said that no beneficial interest. Actually, the Honorable Supreme Court had said that no beneficial interest is created in favor of the nominee.
All right, Mr.
Please, my lords. Then, my lords, paragraph 32 also is also relevant. Perusal of the impugned order of the trial court shows that appellants had brought the 2015 amendment to the notice of the trial court, including the judgment of the Rajasthan High Court in Ram Gopal so-and-so, but the trial court has not even dealt with the legal issue raised before it and allowed the application under order 12 rule 6 based on the unamended provisions of Section 39. It is settled law that the rights of the parties to a lease have to be decided in accordance with the statutory provisions and law that prevails on the day the cause of action arises. And then, my lords, the interpretation given by various high courts, I would like to place before the Honorable Court. Well, immediately after this amendment comes the judgment from Allahabad High Court, Honorable Allahabad High Court, which is at page 38. May kindly have for a moment.
Yes.
But it is Javitri Devi versus Srimati Meera Devi. In this case, Javitri Devi was the mother and nominee of the deceased policyholder. Meera Devi was the wife and legal heir. So this was the case. In this case, my lords, insurance policy was not in question. The dues of the insurance policy were not in question. Only the service benefits of the deceased person were in question. Although in this case 39(7) was quoted, but this case, may kindly see the findings at page 39. The issues were before the Honorable Court at page 39, paragraph 7.
Yes.
The issue was at the time of the admission of second appeal, following substantial question of law were framed, whether the amount of pension and retirement benefits can be paid only to the nominee and not to the other legal heirs and representatives of the deceased. If so, what is its effect? And then, para 9 also, the dispute between the parties relates to entitlement of pension and retirement benefits of the said late Shri Laturi Singh. So, in this case, these dues were given to the legal heirs and not to the nominee. Because the issue was not 39, the insurance policy
Let
was.
us confine to 39 only, no other law.
No,
We are
right,
dealing with 39. Forget other provisions, particularly because there has been amendment in 39.
Please, my lord.
We have to confine ourselves to this.
No,
If there is
because
some decision, we will consider. Otherwise, the law is well settled that if there is nomination made, then that is, you can say, collector's responsibility or his interest.
no, my lords, why I'm trying to mention is because the learned.
You are trying to convince us, Mr. Parasar, and we are not against you, that because of the amendment in section 39 in 2015, if someone is nominated in the policy, he or she has the beneficial interest.
Please,
This
my
is
lords,
not permission. That's all.
Please, my lords. Now, why I'm trying to, place these judgments, my lord, because my learned friend had tried to place reliance on all these judgments, whereas these are distinguishable. So that is why I
We assure you, Mr. Parasar, that we shall not look into any other judgment than amendment on section 39.
Please, my lords.
If there is some judgment on section 39 post 2015, it's all right. Otherwise, if the situation according to them has not changed despite 2015, that will consider. Otherwise, there is no.
Please, my lords. Then I am coming to the judgments where 39 has
Because there
been
are
dealt with.
hundreds of judgments. We will not see that. We need to confine to this provision only.
No, yes, I'm coming to only those, referring to those, judgments, my lords, where 39 has been, a judgment has been passed in 39(7).
39 post amendment.
Please, post amendment, please, my lords, may kindly see. So this is paragraph Shweta Singh, my lords, I have already discussed that the Honorable High Court of Delhi has in paragraph 30 and 31 has given its findings.
Yes.
Please, 30 and 31 I have already, my lords, brought to the notice of the Honorable Court. Then I am coming to the, my lords, another judgment at page 63.
Page
63 of my compilation.
What is that?
And that's a judgment passed by the Honorable Andhra Pradesh High Court in 2023 on the import meaning and of section 39(7). It has been interpreted by the Honorable Andhra Pradesh High Court in this judgment.
Yes.
Members may kindly see page 71 of this compilation. Page 71.
Yes.
Page 71 and para 11 merits, where the beneficial entitled has been discussed, and what is the meaning of beneficially entitled has been discussed, which is used in this 39(7). Para 11, a careful perusal of subsection 7 of section 39 would indicate that the words beneficially entitled are employed for the first time in subsection 7 of the amended section 39, which we do not find in the original section 39. In my considered view, the legislative intendment is manifestly clear from the words beneficially entitled, which means the nominee or nominees shall receive the insurance amount on the death of the policyholder in their own interest, in exclusion of other heirs. My view gets fortified from the interpretation given to the words beneficially entitled in the treatise Law Lexicon by renowned author Shri P. Ramananda Iyer in his second edition. The words beneficially entitled are defined as follows. Beneficially entitled to possession does not mean entitled and deriving a benefit from possession, but beneficially entitled in the sense of being entitled for one's own benefit if there is any benefit to be derived from the estate, and not simply as trustee for others. Then further, it say in paragraph at page 73, may kindly have page 73, may kindly come. Paragraph 14. While so learned judge of this court happened to consider the effect of amended section 39 in Karnam Shrisha versus Insurance Regulatory Development Authority, learned judge observed thus. Under the amended subsection 7, a beneficial interest is created in favor of the nominee when such a nominee is one of the members of the family of the holder of the insurance policy enumerated in subsection 7. The enumerated nominee is not just an agent or trustee of the legal heirs.
In this case, the view taken by the Delhi High Court has been approved.
Please, my lords. Yes.
Yes, already.
Yes.
No approved, it's followed or.
Yes. And then, my lord, paragraph 15 says, 14 further says, enumerated nominees is conferred with an independent beneficial right over the money received by the enumerated nominee, where an enumerated nominee dies after the death of the holder of the policy and before receiving the sum assured. Subsection 8 mandates that the legal heirs of the enumerated nominee are entitled to receive the sum assured and not the legal heirs of the policyholder.
Yeah.
So the Honorable Court has also given interpretation of section 39(8) also.
All right.
And Mallards may kindly see then further para 17. Viewed from any perspective, the provisions of section 39 of the Insurance Act now provide a right to the nominee enumerated in subsection 7 and 8 to receive the sum assured and his or her right and not as an agent of the legal heirs of the policy. Please.
Anything else, Mr.
Mallards, then another judgment is at page 75.
Page
75, Mallards.
Which judgment?
Of this compilation, Mallards, my compilation. K.R. Sakti Murugeshwari. This comes from Madras High Court. Honorable Madras High Court in October 2023 has also interpreted section 39(7). And I'll take on the Honorable Court to just to the ratio, which my lords may kindly turn to page 86. I'm coming to the ratio. Page 86, paragraph 7. My lords are there?
Yes.
A careful reading of the above judgment brings to light the fact that the dictum of the Honorable Apex Court in Sarvati Devi case to the effect that a mere nomination would not confer any beneficial interest on the nominee under an insurance policy has undergone a change by virtue of amendment that was brought in Parliament by the Parliament to section 39 of the Insurance Act.
Yes.
Before this amendment was brought in, the Law Commission had also submitted its views, and the Law Commission wanted to specifically carve out the distinction between beneficiary nominee and the collector nominee. However, when the legislature amended section 39 of the Insurance Act and brought in subsection 7 and 8, the very concept of collector nominee has been done away with. This was taken into consideration by the Delhi High Court, and considering the facts and circumstances of that case, the nominee who was appointed under the policy was held to be the beneficial nominee and was hence entitled to appropriate entire sum assured. Please, then section 8, my lord, this para 8. There is yet another reason as to why this court has to hold that nominee takes the sum assured absolutely. For this purpose, subsection 8 to section 39 of the Insurance Act becomes relevant. This provision states that even if in case the nominee dies, the legal heirs, legal representatives of the nominee will be entitled to the sum assured absolutely. This gives a clear indication that the nominee, who is the nominated by the policyholder, takes the sum assured absolutely and for all purposes is treated as a beneficial nominee. The facts of this case before that did not anyway. So then another judgment, last I would be quoting, that comes from the Honorable, again from the Honorable Andhra High Court. At page 89, that also interprets section 39, amended section 39, and this is dated November 2020.
Where are you reading? Which paragraph?
Paragraph, my lords, I am reading at page 99.
And have you read paragraph 12 at page 87?
Paragraph 12 at 87, my lords. 87. Please, my lords, yes. Please, my lords. Paragraph 12. A beneficial nominee means the nominee who is entitled to receive the entire sum assured under the insurance policy absolutely. On the other hand, a collector nominee means a nominee other than a beneficial nominee. It is true that On the plain reading of section 39(7), this distinction has been done away with. However, the legislature was careful enough to identify who all will fall within the category of nominees who in law will be considered as beneficiary nominee. While categorizing those persons, the legislature was careful enough to bring in parents, spouse, and children, or any of them. If the legislature had thought it fit to make anyone as a beneficiary nominee, there was no need for the legislature to specifically, yes, my lords, only a special, category or class of nominees have been made as beneficially entitled, beneficial nominees. And in this case, mother has been made the nominee, absolute nominee, my lords. So this case, I was taking the Honorable Court to the observation of Honorable Andhra High Court in the case of Karnam Sirisha versus Insurance Regulatory Development Authority. But make for once have page 99. For a minute, page 99, that is paragraph 99. So sorry, paragraph is page 99, paragraph 16, Maras. May kindly please have for a minute. Para 16 at page 99 words of this compilation.
Yes.
Under the amended subsection 7, a beneficial interest is created in favor of the nominee when such a nominee is one of the members of the family of the holder of the life insurance policy enumerated in subsection 7. The enumerated nominee is not just an agent or trustee of the legal heirs of the policy holder. The enumerated nominee is conferred with an independent beneficial right over the money received by the enumerated nominee. Where an enumerated nominee dies after the death of the holder of the policy and before receiving the sum assured, subsection 8 mandates that the legal heirs of the enumerated nominee are entitled to receive the sum assured and not the legal heirs of the policy holder. Such a change in the line of succession is because the sum assured is to be received by the enumerated nominee absolutely in his own right, and consequently the legal heirs of the enumerated nominee would be entitled to the sum assured.
All right.
Please. So these are and there are other at page 102, but I'm not bothering the Honorable Court. The same interpretation comes from the Honorable Rajasthan High Court also in Ram Gopal and General Public. So the majority of the High Courts have given interpretation which upholds the right of the nominee, and the 2-3 High Courts, Honorable High Courts have although referred to the sections but not dealt with and given any interpretation. That is why this compilation has been made, which my learned friend has tried to rely upon, but they are not dealing with. So this is I rest my case. So with these submissions.
All right. Thank you. Yes.
Can I request, let it be tomorrow? I'll come with this compilation. Tomorrow, maybe at.
Yes, Mr. Heard the process responsibility on behalf of the appellant to be taken up at. Is there any matter fixed tomorrow? 2 p.m. Oh. All right. We will pick up tomorrow. Maybe in the first half.
Please, madam.
Yes.
Specially urgent category, madam. Special urgent matters.
It will be taken up tomorrow.
Please, madam.
Item 44.
Much obliged.
In item 4, pursuant to Lordship direction, I filed an affidavit by the Lord Secretary Panchayat Department regarding electrification and drinking water facilities in the entire state of Odisha. So far as drinking water is concerned, I have given the details in that. So far as electrification is concerned, because Panchayat Raj is only responsible for saving 10 LED lights in respect of each gram panchayat, that I have given. And so far electrification is concerned, it is to be in the jurisdiction of Energy Department. So the Panchayat Department has requested the Secretary Electric Department to give the details so that they can file the affidavit subsequently. Yesterday only I filed that affidavit. So Lordship may take it up on record and call it some other day, so that in the meantime I can file the affidavit of the energy department regarding electrification in the entire state of Odisha, my lord.
But you will have to do it.
No, so far drinking water is concerned, I've gone through
Drinking
the.
water is one aspect. Drinking, eating is one aspect. But
Yes, Lord.
education is also very important. So if you don't have this.
Electricity, they say that because it is done by the energy department. So the secretary has, I've given the letter also, secretary requested the energy department to give the details of the entire state, my lord. Some time, 2 weeks time.
All right.
I'm giving a copy or also a counter copy I've solved in court.
Counter affidavit has been filed on behalf of opposite party number.
Milords, OP number 2, Milords.
Number 2. Mr. L. Samantrel and AGA have submitted that further affidavit is required to be filed on the issue of electrification in the state of Odisha by state of Odisha, for which he is required to seek instructions from the energy department. To place this matter on so in the meanwhile, the affidavit must be filed.
And another aspect, lawsuit had also directed the collector, Noagar, to file that affidavit. That affidavit also I'll file within these 2 weeks.
That the affidavit, required affidavit on behalf of the collector Nayagar be also filed in the meanwhile.
Item 45.
May I please? In this case, my lord, present petitioner pray for the issue of environment clearance for the operation of the stone quarry, my lord. The present petitioner is executed also the lease agreement for the 5 years, my lord. Your
Which
lordship,
item is this? 45?
Yes, my lord. And present petitioners also have a lease agreement in for the 5 years for the operation of the stone quarry, my lord. But your lordship kindly pair with the Annexure 4, my lord. And last occasion in Annexure 4 series, my lord, they issue the EC on dated 2012-2019, my lord. First EC. Thereafter, and for the Annexure 4, running page 57, my lord, last issue for the 10/8/2020, my lord. Thereafter, my lord, repeated approach, my lord, the present opposite party not issue the EC. In first, in the I have present petitioners agreement also exist, my lord, till 5 years, my lord. In last occasion, by the intervention of the your lordships, my lord, they have issued the opposite party 5. They are agreed to consider our representation, my lord. Your lordship can repair.
But whether you have compared with the court's order, you filed additional affidavit.
Yes. No, additional affidavit already filed, my lord.
You filed.
Yes, my lord. In this case, my lord, with reference to subject cited, I am to say that your representation on dated by 26/2024 and 24/7/2024 will consider on merit after obtaining the cluster EC over the consumer stone quarries. Here, that is the letter issued by the opposite party number 5, my lord. On dated 30/8/2024.
Yes.
So in view of this letter, my lordship can take up this matter after some days so that if it is granted, so no purpose will be solved by pursuing the writ application. In view of this letter of the Lord's authorities, that his case shall be considered. Lord's lordship.
This case shall be considered after environment clearance.
Yeah.
The environment clearance has been granted.
Till today, no granted. Man. Say, they have been a cluster EC, my lord. EC cluster means there is a page of PC, the cluster defined. My lord, I have explained this, my lord. That is running page.
Cluster means group, so.
Yes, my lord. Yes, my lord.
Nearby 4 to 5. So
that is not fixed, my lord. Cluster form when the distance between the peripheries of the one lease less than 5 meters from the peripheries of these lease and homogeneous mineral areas. That is not fixed. After fixed, they will issue. That is their letter.
So what is fixed?
They are not fixed the cluster issue. Opposite party. That is the technical ground. That technical ground is the opposite party, my lord. The stone till today not operated, my lord. Because we have deposited all the query amount fees and all clearance and mining.
What is the period of lease?
Period of lease, my lord.
5 years.
5 years, my lord.
From?
Dated. Your lordship can repair the annexure 1 dated 1 year. The period of lease, the 5 years from until 2027/8/2024 from to 2/8/2019.
19.
Yes, madam.
In the meanwhile, whether you have done something.
Yes, only 2 years will operate it.
Thereafter?
Thereafter, due to the not issue of the environment clearance, my lord, till the present petition not operated the query. That is not our fault, my lord, because we have deposited all the monies and all the things.
EC is not within the jurisdiction of the state government. It's the CIA millards. So now it's pending with the CIA millards.
EC will be issued by some authority outside the country? Or?
No. It's country, but I don't know whether they made him a party.
That is also your agency.
No, I think it's a central agency.
Environment clearance.
No,
who has to grant this environment clearance?
That is the State Environment Impact Assessment Authority, millards. So that millards, we have the authorities have written letter since millards long and is pending with them, millards. So if CIA will be millards a party, they can respond, millards.
State? What is that? State?
Millards.
Impact assessment.
Yes, State Environment Impact Assessment Authority, millards. And that is to be
State Environment Impact Assessment Authority.
And that is to be done by him only, not by the state. Because rule says, if you also look at
Forward it to the government.
we have forwarded now because Rule 29(4) says the lessee shall be responsible for obtaining environment clearance and implementing the environment management plan. So now he has to get the same.
There is a factor. There also they were taking time. We have passed an order that you, if I'm not mistaken, Mr. Mahanti.
Yes.
That
is a major mineral.
The authority is the same, I think.
Yes, CIA is the authority to give clearance.
Give the timeline when they make that inquiry and.
That's a pollution is the party, state pollution is.
29.
Yes, ma'am. Rule 29, sub-rule 4, millards.
Who is the competent authority?
OP number 6, they have made them a party. He is millards, chairman, CIA millards. OP number 6 in the present rate application. Opposite party number 6.
So whether notice has been issued?
No, millards.
Yes, notice issued.
So,
no. But as per the report, they have all tracking report, or they have already received. In the noting also said.
They have a separate council?
No, so separate council.
No, there is no personal appearance. Who is the chairman?
No, sir. I don't know the name. I can obtain instruction.
Six,
12-9.
12-9 served or appearance was fixed at
12-9 delivered.
But when the lease was granted, you must have been given this environment clearance.
Yes, my lord. First time we have got and 1 year already operated in 2019. Thereafter 20 also issued, but after 20 they have not issued the EC.
So are they required to issue every year?
Yes, my lord. Because in this regards, my lord, our plan also approved, mining plan also approved.
No. You are just trying to understand the procedure.
Yes, madam.
So is it required?
Every year, madam. Every year clearance is necessary, madam.
Every year you must be required to have lease also.
No, agreement exists in 5 years, my lord. But EC want to clearance in every year.
No, but please come to section this rule 29.
every year.
Yes, ma'am. See, they are issued every year. Particular periods, not in issue every year, but issue one by one.
Sometimes we are not able to operate it, expired before that.
Yes, my lord. My lord, in my case, my lord, in Annexure 4, they have issued. For series 2 times, they have issued EC, environment clearance. But my mining plan also approved, my lord, for 5 years. And I have deposited all the amounts.
Where is the requirement that you should be, EC shall be issued for only 1 year?
Your Lordship kindly peruse the Annexure 4. In view of the grant of EC, communicated the members affected here, by letter number so and so, in the consent of operation communication of regional office SCB Baleswar, by letter number so and so, hereby allowed the operation of the stone quarry number 59, operating the plot number 263, acres 100 under Khata number 144 by Contempt. In this, these agreements. Yes, madam. In due to some technical difficulties, other cases also in same plot number in same query. Area 59 query. And they have extension also by the direction of the Honorable High Court, my lord. Other cases in same difficulties.
State by the green.
Yes, NG. Before that, but entire area.
No, this has been stated by the tribunal.
Has this been said by the tribunal?
No, this case is not.
After tribunal. After green tribunal. In same area, but after green tribunal, Lord.
Those orders where your lordship granted
Agreement
extension
execute after
on the basis of the stay order passed by the NGT. Your lordship said that because he had no fault, the NGT had stayed the operation. Your lordship directed the state to consider their extension. But here it is not a case of pending before the NGT.
After NGT. So that I have said. Means after pass out the green tribunal order, that agreement executed in the present petitioners. Because our lease period is 5 years.
Date of appearance was fixed to 27/9. They have received, when did you say? 12/9. I couldn't check if any hotel number is inside, that shows on the status.
Mokuta difficulty, counter difficulty. Counter
Collector inspired from document.
The office note indicates that notice of this writ application has been validly served on 12/9. Correspondent number 6 on 12/9/2024. The notice was issued fixing 12/9/2024 and 27/9 as the returnable date. Stop. Respondent number 6 has, however, not entered appearance. Stop. Next, from the pleadings on record, it appears that the petitioner is not in a position to carry out the mining stone quarry activities despite lease granted in his favor because of absence of environment clearance, which is to be granted by the State Environment Impact Assessment Authority. So stop. Next, we have just similar allegations made in different proceedings that it is because of the absence of environment clearance. Chairman, Mr. Timon. No, I don't. Because of absence of that, despite efforts being made by the leaseholders for grant of EC clearance, for grant of environment clearance, they are unable to carry on the mining in the absence of by the competent authority, that is State Environment Impact Authority. So stop. In such circumstance, next, in such circumstance, we are constrained to direct personal appearance of the chairman of chairman bracketed respondent number 6 on Monday. Be personally present in court along with. When did you make the application?
Around after the sent that 5 hours to postal on dated 2/5/2024.
Along with
present
the-
date petition. Present date petition में ना.
When did you make an
Application
application? See, you
for
were
EC.
required to have environment clearance.
Yes, ma'am.
So did you approach?
Yes, madam.
So where is that?
Undated 1 minute. on dated 22/4/2024. 22/4/2024. Another.
Along with relevant records relating to the petitioner's application for grant of EC in respect of, what is in respect of Karanjia Stone Quarry. Karanjia.
59.
Panjamala Stone Quarry.
Panjamala.
Number 59 in the district of? Which district?
Baleswar district.
Baleswar.
But the applications is referring to for EC clearance, it's to the Tahsildar and the mining officer, not to the SIA.
Did you make any application?
That is the important thing.
That is sent to the copy sent to the chairman.
Then how can you blame the authority?
Annexure 10 series, it's to the Tahsildar.
What is this?
Already we have issued the
Mr. Counsel, please come to Rule 29. We go by the rules.
Yes, my lord.
We know law. We don't know what is the practice.
My lord.
Why you are unnecessarily then wasting court's time? The lessee shall be responsible for obtaining environment clearance and implementing the environment management plan. And this clearance you have to obtain from the competent authority. Competent authority is this. You have not approached the competent authority.
I have approached the mining officer, my lord.
Delete it. Let us see what happens. Yes, seek instructions.
Yeah.
And requested on behalf of the state list this matter on 4 weeks. I don't know what we do.
Item 46.
In which date will lordship?
We don't know. After 4 weeks.
46.
Right.
Item 46, my lord, I pray may be taken off 2 weeks after, my lord.
46.
Yes, my lord.
Sorry, sir.
My senior will argue this matter, my lord.
Let you are. No. Not even a day. Begin. Start your submissions.
The third sub item, my lord, in Saptam Kisam Behra, my lord, 18918 of 2022.
Yeah. And who is in the first case?
I am in the second case. Since on the first one, KK requested because of his illness. Illness, he could not come to the court today.
Oh.
The KK Swami who is appearing for the petitioner in the first case. That is why I pray let it come next week. I am here, but because they will make an adjournment, that is why I was not ready for that.
They have not prayed for adjournment, so how it is adjourned? You are saying that because he would pray for adjournment, you are not prepared.
Yes, he requested me let it come. No, I am petitioner, because both have to take off the issue, that is why. And here is a case, if second case will be, I will be permitted to say, only 2-3 sentences, what is the case exactly? All the teachers who are earlier Ganashikya, they have acquired academic qualification, training, as well as PET pass qualifications. They are qualified. While them being declared as a level 5 teacher, brought over to the cadre of the elementary rule, they were in the policy decision, there is no decision that they are to be treated as an ex-cadre. But in methodology, subsequently, which was passed for modus of operation, in there they declared they will be treated as an ex-cadre malad. Thereby, they were forbidding to get forever right to be considered for promotions. Although they are qualified, on the other hand, my lord, those who have not acquired the essential qualification of TT pass, they have been given birth, my lord, under the rule which was under challenge in that batch of cases. Your lordship had extensively and judgment is resolved. In that, the rule 15 of the 2019 amendment rule, my lord, that was under virus of that under challenge. Thereby, the TET qualification was completely exempted for the teachers, those who were appointed prior to 2011. That's why, my lord, if that judgment, my lord, will come, my lord, it will have impact on this case. If it will be my lord, kept after the delivery of that judgment, my lord, it will be better, my lord, so that it will partly govern the issue involved in this case.
All right.
Despite, my lord.
All right.
But if you
this matters, these matters after disposal of WPC number. Happy?
WPC number 10,034
Item 47.
37, my lord.
On behalf of Mr.
I have entered appearance on behalf of OP number 2 yesterday, my lord. A details counter is necessary, but I pray before the lordship a week time.
Who is OP number 2? Who is OP number 2, Mr.?
My lord, I'm in virtual mode, my lord. I'm attending
Who are you appearing for? Who is opposite party number 2?
Executive Officer, Jatni Municipality, my lord. Here is a, my lord, case. I will file a details counter, my lord. I pray some time because yesterday there was a date was fixed for appearance. I have entered appearance yesterday. And I pray time, my lord.
2 weeks?
Yes, my lord.
2 weeks.
Officer.
For so as to enable him, as requested by Mr. So appearing on behalf of opposite party number 2. Does this matter on so and so as to enable him to file counter-affidavit?
Item 48.
But it's item 48. I am for the petitioner, Manoj. This matter was fixed to 28 on consent of the seniors appearing in the matter, Manoj. So, Manoj, Lordship may kindly keep it to
28.
Yes, Manoj.
It says it was fixed to 28.
What do you want?
Manoj, I am for the petitioner. It was fixed to 28. My learned senior, Mr. Sarma, because of the non-availability of learned senior, Mr. Mahanti,
It was to be listed on
Order sheet says it is 20 to be listed on 2810.
2810. All
Yes.
right. Does this matter on 2810?
I'm obliged.
49.
Yes.
May I please? In fact, pursuant to the notice.
Plus today, I have entered appearance for OP number 213. OP number 213, also I have entered appearance today. I have filed my power in the registry. So I pray at least 1 week time may be granted so that I can take instructions.
As requested by Mr.
J. Kotke.
Okay. And counsel. Let's this matter on 2 weeks. 1 week.
1 week.
1 week. So as to enable him to file counter affidavit. Any urgency?
No. My name can be reflected.
Yes.
Listed on
Name of Mr.
30th or first week of November.
1 week. First week of November.
Obliged.